Your Honor, we are now live streaming and you may proceed when ready. Participants, please keep your camera off unless you are presenting, and please remain muted unless you are speaking.
All right, court's ready to proceed on People versus Becker. For the prosecution, I should have, let's start with, I believe it's Mr. Gutierrez, is that correct?
Yes, Your Honor, it's Ms. Gutierrez, but no worries.
Ms. Gutierrez.
Yeah, so my name is Nicole Gutierrez. I will be representing the people, and I will be directing Jordan Markowitz, and I will be crossing Avery Becker, and I will also be delivering the opening statement.
All right, are there any preliminary matters that I need to address?
Yes, but we can do that after introductions if you don't mind, Your Honor.
That's fine, we will. And so I assume the people are ready to proceed.
Good afternoon, Your Honor, ladies and gentlemen of the jury. My name is Anushka Udeshi, and I'm an attorney for the prosecution today. I will be directing Kyle Kuzak and cross-examining Taylor Perkins.
All right, I believe you're for the defense, is that correct?
I'm for the prosecution.
Maybe I have this wrong then. I show Ms. Gutierrez is for the prosecution. Is that correct, Ms. Gutierrez?
Yes, I am for the prosecution, and Ms. Anushka Udeshi and Annie McDonald are my.
Oh,
yes.
I'm sorry. Yeah, I'm sitting here. You're going through the roster. I'm not at that stage yet. At this point, I just was asking if the prosecution was ready and who you are. I'm looking for, I believe it's Ms. Avila for the defense. Could you go ahead and come online with us? Whoever's representing the defense.
No, Your Honor. The defense is being represented by Juan Blas, Daniela Guanano, and Emily Mars.
Unfortunately, what's your team code?
It is GG, I believe.
All right, the roster I got was different than that. All right, well, we'll get through that in just a second. Is the defense ready to proceed?
Yes, Your Honor, the defense is ready to proceed.
All right, so first thing I'm going to do is I'm going to actually swear everybody. So if all of the defense and the prosecution team will raise your right hands. And obviously I can't see it, so I'll take it that you are sworn in or raising right hands. Do you promise that the representation you are about to give will faithfully and truthfully conform to the facts and the rules of the mock trial competition? Let's have everybody unmute for a second and say, I do.
I do.
I do.
I do.
I do.
All right, now, same thing for all of the witnesses. Here's the following oath for the witnesses. Do you promise that the testimony you're about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition? Please unmute, say I do or I will.
I will.
No.
Yes,
All right, and now the scoring panelists. Do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and the rules of the mock trial competition?
I do.
I do.
I do.
All right, thank you. All right, now let's go back, Ms. Gutierrez. I'm going to direct these comments to you. And again, I'm sorry, could the young man who responded on behalf of the defense also come back online? All right, I'm going to rely on you to be the representatives, obviously, of your respective teams in this. For some reason, for the defense, I've received a different name. So I'm actually going to, for the prosecution, I have Ms. Gutierrez, Udeshi, and McDonald. For the defense, is it Juan Blas?
Yes, Your Honor.
All right, go ahead and introduce your team members for me, please.
Oh, all right. Good
No,
afternoon.
no, no, just for the defense. We have your roster and it appears to be correct. So it's Mr. Bloss. I need you to introduce your team members for me.
Yes, Your Honor. It is Juan Blas, Emily Mars, and then Daniela Guadano.
Spell, what's the last person's name? I didn't hear it.
It is Daniela Guadano,
Guadana?
Daiela Guadana.
All right, thank you.
I'm sorry, Your Honor, I believe the defense roster is listed on page 2 of the attached document. If you scroll down to page 2, that should show you the names for the defense.
Oh, okay. Well, that was the mistake I made because I looked at the first page and saw 3 completely different names. All right. So forgive me, but to be quite candid with you, I wasn't looking where I was supposed to be. All right, let's see if I can find that again, though. I apologize. There it is. All right, everybody having been sworn, and Ms. Gutierrez was anxious to introduce her teammates to me and tell me what everybody was doing. Let's go ahead and get started with that.
All right. Sorry about that, Your Honor.
It's okay. It's because I didn't look at the second page. I didn't realize there were 2 pages on the
No, yes,
rosters.
I completely understand. All right. Good afternoon, jury, Your Honor, opposing counsel, or well, good morning. I'm sorry. I will be presenting the opening statement, and I will be directing Jordan Markowitz and crossing Avery Becker.
Okay, and now Ms. Udeshi.
Good morning, Your Honor, ladies and gentlemen of the jury. My name is Anushka Udeshi, and I'm an attorney for the prosecution. Today, I'll be directing Kyle Kuzak and cross-examining Taylor Perkins.
Thank you.
Good afternoon, Your Honor, opposing counsel, members of the jury. My name is Annie McDonald, and I will be an attorney for the prosecution in today's trial. I will be conducting the direct examination of Alex Fuentes, the cross-examination of Blake Van Owen, as well as providing the closing statement in today's trial. At this time, may our witnesses introduce themselves,
Yes.
Your Honor?
Please.
Good morning, Your Honor, members of the jury, opposing counsel. My name is Sumi Bora, and I will be representing Detective Markowitz.
Good afternoon, Your Honor, ladies and gentlemen of the jury, opposing counsel. My name is Kopal Charasia, and I'll be playing Kyle Kuzak.
Good morning, Your Honor, members of the jury, opposing counsel. My name is Alex Goen, and I will be portraying Alex Fuentes.
Thank you. Now, if the defense would introduce themselves.
Good morning, Your Honor. May I introduce myself and my team?
Yes, please.
My name is, thank you. My name is Juan Blas. I'm here with my co-counsel to represent Avery Becker. Today, I will be directing Taylor Perkins and cross-examining Alex Fuentes. May my co-counsel introduce themselves?
Yes.
Good morning, Your Honor, opposing counsel. My name is Daniela Guadana. I will be directing Blake Van Owen, cross-examining Detective Markowitz, and giving the closing statement.
I think we're waiting for Ms. Merritz.
Your Honor, I believe she's having trouble reconnecting. Let's proceed with the other names and we'll see if we can get her online. She
All
may
right,
need to call in.
let's go ahead and go with the witnesses then.
Your Honor, I ask permission that my witnesses introduce themselves.
Yes, please.
Good morning, Your Honor. My name is Marisol Delgado, and today I will be playing Taylor Perkins.
Good morning, Your Honor.
Good morning, Your Honor.
My name is Kevin. I will be playing Blake Van Owen.
Thank you.
Good morning, Your Honor. Opposing counsel, members of the jury. My name is Ramsey Diaz, and I am Avery Becker.
Has Ms. Maris been able to join us?
She's not online yet, Your Honor.
Mr. Bloss, what roles is she going to have?
Yes, Your Honor. Emily Mers will be directing Avery Becker and cross-examining Detective Markowitz, plus delivering the open statement.
Okay, well, we're not going to be able to go very far without her, so let's go ahead and hopefully she'll be able to join us fairly quickly.
Okay, I believe she's joining us now.
Good.
Emily, would you like to please turn your camera on and introduce yourself? Your camera is currently covered.
Sorry about that. I had technical difficulties. Are we on the opening?
Not quite yet. We're waiting for you to introduce yourself.
Oh, my bad. My name is Emily Mers. I'm doing the opening for the defense. I am doing the directs for Avery Becker and the cross for Kyle Cusack.
Okay, thank you. All right, when I first started this, and again, Ms. Maris, everybody's been sworn, so I wasn't sure if you were participating at that time, but we'll presume that. Okay, good. All right, so again, keep in mind, we're going to start the proceedings. There's not going to be any recesses. Obviously, because of the technical issues, we're only going to have the people that are necessary for that portion to have their cameras active and their microphones on. So it'll be the prosecution's opening first, then the defense is opening, and then direct examination, it'll be the prosecution's attorney, the witness, and the defense who's responsible for cross-examining that witness will all be on at the same time. Everybody else should be muted during that exchange. Ms. Gut, obviously the timekeepers, it's real important that you keep track of the time. I've got a clock, I'm sort of keeping track of time as well, but I'm not going to be to the minute like you are. So I'm not sure if the defense has, gotten their timekeeper back on or not. Do we know if the timekeeper for the defense is back on?
Yes, Your Honor.
Okay, good. We're good to go there. All right, Ms. Gutierrez, you indicated that there were preliminary matters that I needed to address. Go ahead.
Yes, Your Honor. The prosecution requests that all stipulated facts be entered into evidence.
And for the defense, any objection?
No, Your Honor.
All right, then those stipulated facts are admitted, and I have a short list of them.
All right, thank you, Your Honor. And we also request that when instructing witnesses to look at exhibits, that they may look at their trial packet while they are instructed to do so. And we also ask, in conjunction with that, that when exhibits are admitted into evidence, that co-counsel may publish to jury by screen sharing.
All right. I'll be real interested to see how smoothly that goes, but yes, obviously I'll allow that. Anything else?
Yes, and we would also like to ask that during closing, the prosecution may reserve some closing time for a rebuttal.
All right, and I'm going to obviously make sure that the timekeepers are real clear. that's the one thing that when closing starts, I will track to see how much time I believe is left as well. But yes, you'll be able to reserve any unused time for rebuttal close.
All right, and then just one last thing. We also request that the timekeeper may remain with their camera on during the duration of the trial to allow us to see the timestamps.
Again, I don't have a problem with that. I just request that they mute their device.
Yes, of course, Your Honor.
Right. All right. Does the defense have any objection to any of the proposals made by the prosecution, Mr. Bloss?
No, Your Honor.
All right. Any additional preliminary matters that the defense wants the court to address?
No, that will be
Yes,
all.
Your Honor.
Yep.
Sorry.
I'm sorry. I thought you were done, Ms. Gutierrez.
Yes, I'm done. Sorry, Your Honor. I'm
All right.
misheard.
Yeah. So then, Mr. Bloss, go ahead.
Yes, Your Honor. We would like the time to be stopped when an exhibit is being pulled up.
Oh, when it's being published, you mean?
Yes, Your Honor.
I don't have a problem with that. Any objection, Ms. Gutierrez?
No objection, Your Honor.
All right. Thank you. Anything else, Mr. Bloss?
No, Your Honor. Thank you.
All right. I don't believe there's anything else I need to address. The rules that I'm supposed to be reading presuppose that we're all sitting in the courtroom together. I'm going to skip those for time economics purposes. We'll go ahead and start. Prosecution, please make your opening statement.
Yes, I will be delivering the opening statement. Your Honor, members of the jury, opposing counsel, have you ever been betrayed by someone you trusted? Have you ever been stabbed in the back by someone you considered a student, a mentee, a friend, someone you believed in? We are here today because of the murder of a deceased Mackenzie Brackman, who was literally stabbed in the back in the doorstep of his own home. But before we get to the gory details and the witnesses present here today, I'd like to paint you a picture. We have a mock trial coach who is committed to helping every single individual on his mock trial team become astute lawyers in his courtroom. This team, however, would consume more of his time than his actual job as an attorney. This coach was Mackenzie Brackman, and he would spend countless hours getting his Colorado high school mock trial team to an impressive competitive level, which allowed the team to move on to the state competition. Despite his wonderful efforts, there was one member on the team that was not too fond of Mr. Brackman's role as the mock trial coach. This person is our defendant, Mr. Avery Becker, a supposed natural at high school mock trial. Mr. Becker became angry with Mackenzie Brackman, angry with Mr. Brackman's overtness towards his lack of effort to put in actual work for his so-called passion for mock trial, essentially criticizing his valued pride. However, Mr. Brackman allegedly robbed Avery Becker's opportunity as a senior to win Best Attorney Award at the state competition by kicking Mr. Becker off the team for vandalizing his car. Acting in rage, Mr. Becker attempted to trash Mr. Brackman's home, but instead ended up killing Mr. Brackman in a fret of fright when finding him home on the day he was only supposed to trash his residence. Thus, desire and vindication were Mr. Becker's motives. To achieve this, he aimed to trash Mr. Brackman's residence, committing second-degree burglary, and killed him as a source of escape, qualifying as first-degree murder. Today, with the help of my co-counsel, we are here to prove that Avery Becker did in fact kill Mackenzie Brackman beyond a reasonable doubt. You will first hear from Detective Jordan Markowitz that has 7 years of experience as a homicide detective. Ms. Markowitz will walk you through the crime scene, being Mr. Brackman's prior residence, and highlight specific details attached to the residence itself that will clearly show Avery Becker's presence within Mr. Brackman's home. And then she will verify Mr. Becker's various locations during the time of the murder through call detail records. Kyle Kuzak, a certified reconstruction crime scene investigator, will then expand on Markowitz's description of the crime scene and go through each piece of available evidence to explain an overwhelmingly convincing theory of how the murder likely occurred. A burglary gone wrong that spiraled out of control, ending in Mr. Brackman's tragic death because of Miss Becker's prized desire. And the final witness, Alex Fuentes, will collaborate on Miss Becker's actions during her time on mock trial before she was kicked off the team, clearly identifying the tense relationship between Mr. Becker and Mr. Brackman. Mr. Cifuentes will also describe the time he saw him at the Fry Shack the day before the murder, while also showing us valuable texts between him and Avery Becker that prove he was going to trash Mr. Brackman's house. Today, the defendant will present witnesses as well, in addition to Avery Becker. Mr. Becker's best friend, Taylor Perkins, will attempt to confirm Avery Becker's alibi on the day of the murder. However, all that will be revealed is her inherent bias for her friend and Mr. Becker's obvious hatred for Mackenzie Brackman. Lastly, the wonderful Blake Van Owen that will feed you a twisted replica of the theory of the prosecution without offering actual information to corroborate her theory. While the defendant's side will seek to instill doubt in your mind on Avery Becker's role within the case, the motive and evidence connected to Avery Becker is the sole proof that Avery Becker did in fact kill an unfortunate Mackenzie Brackman. In addition to this, the defense will attempt to turn the storyline of the case into fiction, making you believe that another person is guilty for the murder of Mackenzie Brackman. The theories may make you rethink the definition of a reasonable doubt, but for clarification, a reasonable doubt is defined as a doubt based upon reason which arises from a fair consideration of all the evidence or a lack thereof in the case. Thus, if you, the jury, find from the evidence that each and every element of the crime has been proven beyond a reasonable doubt, you must find Avery Becker guilty of the murder of Mackenzie Brackman in the first degree. Thank you.
Thank you, Ms. Gutierrez. For the defense, opening statement.
Yes, Your Honor. May I proceed?
You may.
Thank you. Good morning, members of the jury. My name is Emily Mers, and along with my co-counsel, Juan Blas, and Daniela Guandana, I represent Avery Becker, who has been wrongly accused of killing his mock trial coach, Mackenzie Brackman. This case is about the police taking the easy way out and only looking for evidence to confirm whatever gut feeling they may have had. Today, you will hear from my client, Avery Becker. Avery is just a normal kid who did and said some things that he's not proud of, such as vandalism, but he is remorseful and did everything in his power to make it right. Today, you'll see that he is not a murderer, far from it. The prosecution accused Avery for the death of Mr. Brackman that occurred on March 6, 2020. As you are listening to their witnesses and reviewing the evidence they present, notice how they only talk about evidence that they think points to Avery. But through the witnesses and evidence that my colleagues and I will present, you'll see a much larger picture, one where there are multiple suspects who had the motive, means, and opportunity to kill Mr. Brackman. One suspect who's far more likely to have done this than Avery. When you consider the case as a whole, you'll find that the prosecution did not do their job. They only looked for evidence pointing to Avery instead of the whole picture and ignored everything else. The prosecution brought this case against Avery Becker. That means that the prosecution has the burden to prove its case beyond a reasonable doubt. Avery does not have to prove anything, but the evidence will show that the prosecution cannot meet its burden. They cannot prove to you that Avery killed Mr. Brackman because they ignored all the evidence that pointed away from Avery. They made up their mind and then found their evidence. That's not how this is supposed to work. That's doing it completely backwards and upside down. What they should have done is go where the evidence led them. They didn't, and now there is a murderer walking free. You will hear from several defense witnesses, including Taylor Perkins, Avery's best friend, and Blake Van Owen, a private investigator. Now, Taylor will tell you about how long she has known Avery and how well she knows him. You will hear from Taylor that Avery could not have committed this heinous crime because Avery was with Taylor the entire day on March 6, 2020. They skipped school to look for Avery's phone. They retraced their steps from the day before, but didn't find it. Then we have Blake Van Owen, who will talk about the missed corners the prosecution took, such as not getting the cell tower data on surrounding towers. He will share his findings and how the prosecution contradicts it. Lastly, you'll hear from Avery himself. Avery will tell you that he's just a normal kid who has some ugly things in his past, but he could not have killed his mock trial coach, let alone anyone, over disagreement and mock trial. You'll also hear from the prosecution's witnesses, Detective Markowitz, Mr. Kuzak, and Alex DeFuentes. Detective Markowitz will tell you all the evidence that he has. Notice how he never actually checked Alex's phone for the screenshots that you will see later on. He only accepted them as they were given. Just one of the many mistakes taken. Then, Kuzak will talk about their findings related to what they think Mr. Becker did, while at the same time looking over another suspect and not even having information on the third. They also have Alex DeFuentes. Alex is also on the mock trial team with Taylor and Avery. Alex will talk about how close that they are with Avery, when, if you'll notice, Alex can't tell you a thing about Avery. Once you heard from all the witnesses, it will be clear that my client, Avery Becker, was not responsible for the death of Mr. Brackman. It will be clear that the prosecution has a lot of holes in their case. We ask you that after you've heard from each side, that you return a verdict in favor of the defense. Thank you.
Thank you, Ms. Mears. The prosecution will call their first witness, please.
Yes, Your Honor. The prosecution calls Detective Markowitz to the stand. All right, we shall begin. Please state your name for the jury, spelling the last for the record.
Jordan Markowitz, Markowitz.
So, Miss Markowitz, what is it that you do for a living?
I'm a homicide detective for the Denver Police Department.
And how long have you been a detective?
Wow, almost, 7 years now, and I started with the DPD 13 years ago.
As a detective, do you have any specialties?
I specialize in anything to do with cell phones. Specifically, I am certified by the American Academy of Law Enforcement in cell phone technology and forensic data recovery.
What did you learn through the training?
I learned how to obtain and analyze cellular records and cell tower data, and how to use forensic software to download information from cell phones.
Have you ever actively used this training during your detective work?
Yes, all the time. I've had to download the contents of literally hundreds of phones, and I've obtained and interpreted cell tower data in over 50 cases.
Your Honor, at this time, I move to admit Detective Markowitz as an expert in cell phone technology and forensic data recovery.
Thank you. For the defense, any objection or voir dire?
Yes, Your Honor. The defense objects that Detective Markowitz is qualified as an expert in these areas. With your permission, I would like to conduct a brief voir dire of Detective Markowitz. To receive your cell phone technology and forensic data certification, you received training. Is that correct?
Yes, that's true.
This training only lasted 3 days, correct?
Yeah, and clearly it was sufficient for the American Academy of Law Enforcement to certify me in that area.
This training was never renewed, correct?
I think these types of training programs are pretty standard. I use it on a day-to-day basis. I don't need to be retrained.
Is that a yes? The training itself was never renewed?
Yeah, I just apply it. So I am trained every day as I learn more and more.
But this training was never renewed, correct? It's a yes or no question.
I didn't retake the class because I did not fail.
Okay, and there was also no other training that you received for cell phone technology, right?
Like I said, I'm trained every day on the job. I do what I do and I do it well.
This is a yes or no question. Please listen to my question. There was also no other training that you received for cell phone technology, correct?
Just the certification course.
Okay. And you also never received any other official training for forensic data recovery, correct?
I don't know
Other
what
than
you
this
mean by official training, but
you only took the 3-day training and you never received any other training for forensic data recovery. Is this right?
I took the training, I obtained my certificate, and now I use it every day.
But isn't it true that the only training you have in these areas lasted 3 days?
Like I said, I'm trained every day. The class was
training. Please listen to my question. The training in these areas only lasted 3 days. Is that a yes or no?
Yeah, the official training for the certificate lasted 3 days.
This training was from the entity called American Academy of Law Enforcement, correct?
Yep.
Your Honor, at this time, I would prefer that Detective Markowitz has insufficient training to qualify her as an expert in cell phone technology and forensic data recovery. She has received training that only lasted 3 days, and the training itself was from the law enforcement.
Thank you. Ms. Gutierrez, any response to the objection?
Yes, Your Honor. Under the Rule of Evidence 702, my witness has years of experience in her field and working with cell phones in multiple cases, and has plenty of background to serve as today's expert testimony for cell phone technology and forensic data recovery, as she has had years of experience. And although the training may have only lasted 3 days, she still has sufficient knowledge on the subject to testify in today's trial.
All right, I'm going to go ahead and accept Detective Markowitz as an expert in the field of cell phone technology and forensic data recovery. I'll allow the jury to weigh the value of any testimony or opinion given by Detective Markowitz, since it appears her certification came from a law enforcement agency self-certifying a law enforcement technique rather than an independent scientific community. And again, whether or not the cell phone technology rises to the expert of a reproducible scientific method for the purposes of gathering cell phone information or data. Again, I'll allow the jury to give whatever weight they deem appropriate, but I will allow the testimony. So your request to have her certified as an expert is hereby granted. You may proceed.
Thank you, Your Honor. All right, Detective Markowitz, I'd like to turn your attention to the case. How did you become involved in the investigation?
We received a report that the victim, who we later identified as Mr. Mackenzie Brackman, was deceased just inside the front door of his house. I was assigned to investigate his death, and I arrived at the scene around 2:20 p.m.
What did you first notice about the crime scene?
When I arrived, the front door was open and the gate to the backyard was unlocked. You could see Mr. Brackman lying just inside the front door of his house.
Can you tell me more about the victim?
It was clear that he had been stabbed. He was lying face down in a pool of blood. There was a large knife next to his body and a wound in his left shoulder. From the angle of the body, it looked like the intruder had stabbed him while he was trying to leave his house.
How were you able to corroborate the fact that there was an intruder?
I actually noticed that there was a Ring camera at the front door. Ring cameras, just so the jury's aware, are cameras that act as motion detectors and record activity outside the home. The footage showed an intruder entering into the house.
Were there Ring cameras anywhere else?
While I was walking around the outside of the home, I saw a Ring camera aimed at the gate to the backyard and another camera aimed towards the backyard door.
How did you obtain these video recordings?
It was actually quite easy. I got access to Mr. Brackman's phone and I downloaded the contents and information. He was actually paying a monthly fee to keep access to recorded events downloaded straight onto his phone, so I could access the footage from March 6th.
All right, so if I showed you a Ring video related to the homicide, would you recognize it?
Yes, of course.
Your Honor, may I have permission for co-counsel to screen share what has previously been marked as Exhibit 12?
You may.
Detective Markowitz, did you recognize that video?
Yes, this is one of the videos we collected from the Ring camera footage.
Is this a fair and accurate representation?
Yes, it is.
How do you know that these videos accurately show what happened outside of Mr. Brackman's home?
Like I said, because Mr. Brackman paid a monthly fee for the cameras to download recorded events onto his phone, there was no third party involved and no one besides Mr. Brackman and the police had access to it.
Your Honor, I now move to admit Exhibit 12 into evidence.
Defense, your position?
No objection, Your Honor.
I'm sorry, I didn't hear you.
No objection, Your Honor.
Oh, no objection? All right, then Exhibit 12 is admitted without objection.
All right, thank you, Your Honor. May I proceed?
Yes.
What is depicted in this video, Detective Markowitz?
The intruder goes through the backyard and enters the house.
Is there anything else important about the video?
There are actually two important details for the jury to note. First, the intruder is the same height and build as the defendant, Avery Becker. And second, the Halloween mask shows that the intruder had criminal intent, i.e. they masked their identity because they planned to do something illegal.
Moving on, you mentioned you downloaded the contents of Mr. Brackman's phone. Did you find anything else relevant to the investigation?
I actually found lots of texts and emails related to something called mock trial. Apparently, Mr. Brackman was a high school mock trial coach for Colorado High School.
What did you do with this newfound information?
I reached out to the school and I obtained contact information for all of the students on the team. And then I reached out to one of the students, Alex Cifuentes, and he identified Avery Becker as a potential suspect.
Can the defendant please turn the camera on so Detective Markowitz can identify them? Just so the jury is clear, do you see Avery Becker in the courtroom today, Ms. Becker? Or Ms. Markowitz, I'm sorry.
Yes, he's the person in the black blazer.
All right, thank you. You can turn your camera off now, Mr. Becker. All right, and what information did Mr. Cifuentes give to you?
He sent me screenshots of text message conversations between Ms. Becker and himself, or I'm sorry, Mr. Becker and himself, showing his intent to trash Mr. Brackman's home on March 6th.
So knowing this about Mr. Becker, what did you do?
I tried to have Mr. Becker come in for an interview, but he didn't end up coming, unfortunately.
Okay, so what did you do next?
I obtained a warrant to search Mr. Becker's phone. It turns out he had conveniently lost his phone the day before the murder. I was still able to access Mr. Becker's account records and cell tower records and data through his service provider.
What are cell tower records?
Cell tower records can help you pinpoint someone's location based on the cell towers their phone connects with. They're technically call detail records, so whenever you send or receive a call or text, a record of that interaction is created. And a cell phone is also constantly reaching out to find cell towers it can communicate with, even when it's not in use. So if you can access all of the cell towers in an area, you can pretty accurately find out where someone is or was.
So what specific information does the call detail record provide?
It shows many things: the date and time of the communication, whether it was incoming or outgoing, the number the phone was in communication with, whether it was a call or text, and the cell tower the phone communicated with, including the antenna. The only thing it does not provide is the content of the communication.
And how does a cell phone choose to connect with a specific tower?
Most of the time it will connect with the tower nearest to it. Obviously, there might be some obscurities, but I would say the majority of the time, almost all of the time, it will connect to the tower nearest to it.
And how did the call detail records help in your investigation of Mr. Becker?
We found that Mr. Becker received several calls and texts from Taylor Perkins leading up to Mr. Brackman's murder. And we also found that Mr. Becker traveled from his house towards Mr. Brackman's home, arriving there around the time of the murder.
Were you able to record the cell tower data?
Yes, I actually put together a diagram of all the information.
So if I show that diagram, would you recognize it?
Yes, absolutely.
Your Honor, permission for co-counsel to screen share what has previously been marked as Exhibit 16.
You may.
All right, Detective Markowitz, I am not showing you what has previously been marked as Exhibit 16. Do you recognize it?
Yes, this is a copy of a diagram that logs all of the information from the call detail records.
Is this a fair and accurate representation?
Yes, it is.
Your Honor, I now move to admit Exhibit 16 into evidence.
And defense, your position with regard to People's Exhibit 16.
No objection, Your Honor.
All right. People's Exhibit 16 is admitted.
All right, thank you, Your Honor. Could you please give a brief description of what the diagram shows, Detective Markowitz?
It shows the locations of the cell towers that Mr. Becker's phone communicated with on March 6th in the time leading up to the murder. The antenna on each cell tower have a 120-degree arc, so we can see that Mr. Becker's location in relationship to the cell tower as well. It also shows a possible route that he took towards Mr. Brackman's home.
Based on the map in the CDRs, where was Mr. Becker before the murder?
Mr. Becker received a text from Ms. Perkins at 12:47 p.m. that went through cell tower 12273, so they were likely near at their home.
What was the second cell tower that Mr. Becker's phone communicated with?
They received another text from Ms. Perkins at 12:55, and it went through cell tower antenna 11911, located on Rock Creek Parkway, traveling towards Mr. Brackman's home.
What's Rock Creek Parkway?
Looking at the map, Rock Creek Parkway is the primary street which connects to the homes of Becker and Brackman.
What was the last cell tower that Mr. Becker's phone was in communication with?
An incoming phone call came from Ms. Perkins at 105, another at 106, and a text at 117. The last communication went through cell tower antenna 1197, which means that Mr. Becker was near Mr. Brackman's house around the time of the murder.
Okay, so just so the jury is clear, what does all of this indicate?
It indicates that Mr. Becker was at home somewhere between 12:45 and 12:50 p.m. Around 12:55, he left, drove towards Mr. Brackman's home, going along Rock Creek Parkway. And then at 1:05 to 1:17 p.m., Mr. Becker was at Mr. Brackman's house.
How can you tell when all activity on a phone stops?
It will only stop when the phone is turned off all the way or placed in airplane mode, and then it will stop communicating with the cell towers near it.
Did the activity on Mr. Becker's phone ever stop?
It showed that all activity on Mr. Becker's phone ceased at 1:20 p.m., briefly after the murder.
All right, in your expert opinion, who broke into the home of Mackenzie Brackman?
Avery Becker.
And who killed Mackenzie Brackman based on the evidence we received today?
Mr. Avery Becker.
No further question, Your Honor.
Thank you. Cross-examination.
Yes, Your Honor. Good morning, Ms. Markowitz. First, I would like to talk to you about all the evidence you gathered at the crime scene. While you were at the crime scene, you took pictures of the blood spatter, is that correct?
I did.
And you no longer have access to these pictures, is that right?
Unfortunately, the files were corrupted. That's why we didn't include it in my testimony here today.
And isn't it correct that the pictures of the blood spatter are completely unrecoverable?
Yeah, like I said, they were corrupted. Again, that's why I did not testify to it today.
Detective Markowitz, if I understood your testimony correctly, you consider yourself to be an expert in forensic data recovery, correct?
Yes, I do.
But despite your expertise, you have absolutely no ability to recover these lost photos.
I think you're a little bit confused about what forensic data recovery is. What forensic data recovery actually is?
Thank you. So you're telling me that you have no ability to show the jury these photos today, right?
No, again, the files were corrupted.
Next, I would like to talk to you about some of the evidence in the case. After reviewing the crime scene, you interviewed Missy Fuentes, is that right?
Yes, I interviewed him.
And you did this even though you thought Mr. Brackman's mock trial activity had a small possibility of anything to do with his death, correct?
Again, I go where the evidence takes me. It was a possible lead, so I took it.
In the interview with Missy Fuentes, you learned that Missy Fuentes didn't have his phone, correct?
Yeah, he unfortunately forgot it.
And when you learned this, you only asked Fuentes to send screenshots of the text messages, correct?
Yes, after receiving the screenshots based on my experience, I decided that it was sufficient.
Thank you. You never confirmed or verified that the screenshots were accurate copies of what was on the actual phone, correct?
Like I said, I've been doing cell phone data recovery for almost a decade. I think I can know when screenshots are reliable.
But you never confirmed the screenshots itself with the phone, correct?
I used my expertise and my experience to make sure that they were reliable.
For the sake of the jury's time, can you please answer yes or no? You never confirmed that the screenshots were accurate copies of what was on the actual phone, correct?
I don't know what you mean by confirmed. I relied on my expertise.
You never had the actual phone to look at to confirm if the screenshots were accurate, did you?
I did not take his actual phone.
Thank you. You received cell tower records, right?
Yes, I analyzed them.
And you agree that the record from the CDR identifies the cell tower that was used, correct?
Yes, it does.
You also think that there's an algorithm that pairs a cell phone with the best available tower, correct?
I know that there's an algorithm that does that.
But you stated that the phone usually connects to the nearest tower, correct?
Yeah, the majority of the time the phone will connect to the nearest tower.
However, a phone does not always connect with the tower closest to it, right?
It's quite unlikely that it'll connect to a different tower. Obviously, there's some margin for error, but extremely unlikely.
But you do not know with 100% certainty that the cell phone will connect with the tower that is closest to it, correct?
It's impossible to know anything with 100% certainty.
Thank you. You cannot base the location of Mr. Becker's phone off of the towers with 100% certainty, correct?
It's impossible to know anything with 100% certainty.
Next, I want to talk to you about why further investigation into other suspects was not completed. You mentioned the possibility of an outcome of the case being the work of a disgruntled ex-client, correct?
Yeah, I considered it, but I didn't want to jump to conclusions.
Okay, but you never considered any ex-clients of Mr. Brackman, is that right?
Again, I even testified to the fact that I considered it would be an ex-client, but I'm not going to investigate someone who we don't know is guilty. Or we don't even think is
I would also like time for bring up Exhibit 16, which has already been admitted.
Yes, I can review it. I have it in front of me.
Okay. It says Blair Rollins' house, doesn't it?
Mr. Rollins' house is marked on the map.
Thank you. And you made this exhibit, correct?
Yes, I made this exhibit.
Thank you. So this means you're familiar with Blair Rollins, right?
I know where he lives.
Objection.
And you know that.
Excuse me. Ms. Guardana, if you would wait, Ms. Gutierrez is voicing an objection. Go ahead, Ms. Gutierrez.
Yes, thank you, Your Honor. Objection, relevance.
Your
And
Honor, my apologies, Your Honor. May I answer?
yes, please.
Your Honor, our theory is that there is an alternate suspect. There is somebody that the police did not look into. This is simply ridiculous, and I think it would benefit the jury to hear more about this alternate suspect.
Okay. Minus the editorial comment about ridiculousness, your theory of alternate suspect is the subject matter of the line of questioning. I will find that it's relevant. I'll go ahead and allow the questioning. And Detective Markowitz, did you consider, I believe the question was with regard to Rollins, did you consider that when putting the Rollins mark on the map that could be an alternate suspect?
Yes, I did decide to put Mr. Rollins on the map just in case we needed that data later.
All right, thank you. Ms. Guadana, you may continue.
You never interviewed Blair Rollins, did you?
No, I was not able to obtain an interview.
No further questions, Your Honor.
Thank you. Any redirect examination, Ms. Gutierrez?
Brief redirect, Your Honor. All right, Detective Markowitz, just to confirm, you did place Mr. Becker's phone in the vicinity of Mr. Brackman's home?
Yes, Mr. Becker's phone was right where Mr. Brackman's house was. Unfortunately, Mr. Rollins' phone is not shown to be near Mr. Brackman's house.
And why didn't you question Blair Rollins or look into Blair Rollins, just to clarify for the jury?
Yeah, so obviously we considered Blair Rollins as a potential suspect, but there was no evidence indicating that Blair Rollins had anything to do with the crime. They're kind of putting themselves in a double bind here because they're asserting that I didn't consider any other suspects, but then they're asking why I did consider other suspects. It's a little confusing.
All right, no further questioning, Your Honor.
Thank you. The witness is excused. You can mute your device. The prosecution's next witness, please.
Yes, Your Honor. The prosecution calls Ms. Kyle Kuzak to the stand. May I proceed, Your Honor?
Yes, Ms. Cusack, you've been sworn. You can go ahead and proceed, Ms. Udeshi.
Thank you, Your Honor. Ms. Kuzak, please state your name for the jury, spelling the last for the record.
Kyle Kuzak, K-U-Z-A-K.
And Ms. Kuzak, what is your current job?
I am a certified crime scene reconstruction investigator at the Colorado Bureau of Investigation.
And how many years of experience have you had?
I have been working 19 years investigating in complex crime scenes, most of which have been around the country, but my most recent 3 years have been with City of Denver.
Wow, that's a really long time. And what type of crimes do you investigate?
I tend to investigate home invasions, burglaries, other property crimes, and homicides and fatal accidents, and sometimes armed robberies as well.
And how are your years of experience related to this case?
I have had a lot of experience investigating homicides and home invasions specifically, which is what I saw at 44 South Flower Street at the victim's house.
Your Honor, under Rule 702, I move to admit Ms. Kyle Kuzak as an expert in crime scene reconstruction and complex crime scene analysis, as she has many years of experience dealing with complex crime scenes, and she was also a certified crime scene reconstructor. Sorry.
That's fine. For the defense, your position?
No objection, Your Honor.
All right, then the court will recognize Kyle Kuzak as an expert in crime scene reconstruction and crime scene analysis.
Thank you, Your Honor.
You may proceed.
What are the guiding principles in your work, Ms. Cusack?
I have two principles that guide my
Objection
work.
leading.
I'm sorry, I heard an objection.
Yes, Your Honor. Objection leading question.
I'm going to overrule the objection. I don't believe that that was leading. It didn't suggest the answer. So you may go ahead and answer that question, Ms. Kozak.
All right. So there are two principles that guide my work. First, I assume that every case is going to trial, so I conduct a thorough and comprehensive investigation accordingly. Secondly, I memorialize, document, and organize all the evidence in a manner with the mindset that there may be future reconstruction of the crime scene.
And how do you approach a typical complex crime scene?
To conduct an effective and accurate, efficient flow of my CSR work, I approach every crime scene in 5 steps. First is recognition and documentation. Second, collection of evidence. Third, evaluation of evidence. Fourth, hypothesis and testing. And fifth, reconstruction.
And how did you start your investigation at the victim's house?
I approached this case as I would any case, with my 5 CSR trained and tested steps, as well as my 2 principles. I drew timelines, reviewed photos, and watched ring security footage. And through organizing all of the evidence, I developed my hypothesis and also had my case file reviewed by others, as it is considered a complex crime scene.
And you mentioned you reviewed some photos. Could you please elaborate?
Yeah, so those photos just showed some blood droplets from the kitchen to the front door, and organizing this showed a clear chronology that the victim was stabbed near the kitchen and proceeded to the front door where the knife was pulled out and dropped. Unfortunately, those photo files were corrupted after my review, but they did not affect the development of my final theory.
And while at the crime scene, what else did you observe?
I also noticed some scuff marks, a broken dish, and an open knife drawer.
And if you saw photos of these items, would you be able to recognize them?
Yes, I would.
Your Honor, permission to let my co-counsel present their screen, which will display what has previously been marked as Exhibit 7, 9, and 18.
Okay, let's start with Exhibit 7. And we'll take them one at a time. Go ahead.
Thank you, Your Honor. And what does Exhibit 7 show?
So this is a photo of the knife drawer. As you can see, it has a large assortment and brands and types of knives in the drawer.
And co-counsel, if you could just go down to 9. What does this document show?
This photo shows the broken plate near the kitchen table.
And co-counsel, if you could please go to Exhibit 17. And what does this document show?
This document, I thought it was Exhibit 18 that we discussed.
Yes, Exhibit 18. Yes.
Sorry, so these photos show scuff marks near the back door.
Can you please elaborate to the jury the significance of these photos?
Yes, these photos clearly depict a struggle. In my investigation of this case, I took into account all of this evidence to create my theory.
And is this a fair and accurate representation of what you saw at the crime scene?
Yes.
Your Honor, I move to admit Exhibits 7, 9, and 18 into evidence.
Okay, Ms. Maris, your position, let's start with 7, the photo of the knife drawer. What's your position with regard to that?
To Exhibit 7, I object to irrelevance, Your Honor.
Would you like me to respond to that, Your Honor?
Yes, you may, Ms. Udeshi.
Well, considering that the murder weapon was in fact a knife and in the victim's house, there's a large assortment of knives, I believe this is relevant in the case.
May I respond, Your Honor?
Go ahead.
As far as we can see, this is just a drawer filled with a bunch of knives and or kitchen utensils. So therefore, it does not necessarily prove that it is relevant to the case because it shows no background information.
All right. The exhibit was offered to corroborate the witness's testimony to reflect evidence of a struggle. Although I will note this may have marginal value, I'm going to admit it over objection and allow the jury to give it whatever weight they deem appropriate. The only consistent factor being that the photograph shows knives, and evidently the victim died by means of a stabbing with a knife. So it may have some moderate value. So your objection to its admissibility is overruled. Exhibit 7 is admitted over objection. Let's go to Exhibit 9, the photograph of the broken plate. What's the defense's position in that regard?
No objection to this one, Your Honor.
This one is admitted then. And then to Exhibit 18.
Objection speculation.
Okay. And Ms. Udeshi, would you like to respond to the objection that the photograph of the scuff marks are objectionable based on speculation?
Yes, of course, Your Honor. This is a rationally based assumption under Rule 701 of what could have happened during the potential actions within the crime scene.
May I respond, Your Honor?
You may.
As far as we know, these scuff marks could have been made within the last 5 years. They could have been made last week. So it is not definite that these were an indication of a struggle between the victim and the killer.
All right. I'm going to go ahead and again allow the jury to give whatever weight they deem is appropriate to the contents of People's Exhibit 18. There is no evidence directly connecting this to the events of March 6th. However, I will again allow the jury to determine what, if any, weight this has to corroborate the witness's Kozak's suggestion that the evidence supports evidence of a struggle. So I'll go ahead and admit it over objection. Thank you.
Thank you,
You may
Your Honor.
continue, Ms. Udesh.
Thank you. And Ms. Kuzak, based on your 5-step process you mentioned before, what did you determine to be the sequence of events in this murder?
Yeah, so first the perpetrator stopped at the front porch of the house and tried to open the front door, and then they proceeded to the back door of the residence and entered through there because those are both captured by the ring security footage.
Your Honor, permission to let co-counsel screen share the footage of Exhibit 12, which has previously been moved to evidence.
You may.
Thank you, Your Honor. And Ms. Kuzak, what does this footage show?
This shows the intruder entering through the back door of the residence. In these videos, it is clear the intruder is wearing gloves, which is why no fingerprints were recovered from the crime scene.
And considering your processes and evidence, what is your theory of this case?
The physical evidence on the scene has led me to one conclusion. This was clearly a planned burglary gone bad. The intruder clearly had knowledge of the victim's residence and chose a time of day at which the victim would be out of the house. Unfortunately, they were home and were alerted to the intruder's presence from the ring security footage. So the victim grabbed a knife from the knife drawer seen in Exhibit 7, and then there was a struggle, and then ensuing struggle, the scuff marks and the broken plate occurred, and unfortunately the victim was killed by the very same knife that they brought to defend themselves.
And why do you believe this break-in was just not random?
The intruder clearly had planned this break-in because they were wearing masks and gloves and intended to enter the victim's residence with malicious intent. This is fact, not fiction.
And are you switching topics? Are you familiar with Blake Van Owen?
Yes, I do know him. I've met him at several crime scene reconstruction conferences. However, he is just a police officer and was never an actual CSR like myself. He only reviews the work of actual crime scene reconstruction.
Objection narrative.
Response, Ms. Udeshi?
My witness is just showing the how she is acquaintanced with Blake Van Owen.
All right, I believe her response went beyond acknowledging her familiarity with Blake Van Owen. I'll sustain the objection.
Thank you, Your Honor.
I will move on, Your Honor. Do you know Mr. Van Owen's theory of this case?
Yes. In my reports for this case, I reviewed everybody's statements, and Van Owens believes that the intruder grabbed a knife and sneaked up behind the victim and stabbed him in the back, while the victim was unaware. In my expert opinion, this is a kind of conclusion that can be reached by first having a predetermined outcome and then cherry-picking evidence to support that outcome.
And in your expertise, why would this theory be impractical?
As a crime scene reconstructant, I have learned to take into account all the evidence. And as you can see by evidence of the broken dish and the scuff marks, this was clearly not a random sneak attack. Van Owens' theory also assumes that the ring app did not alert the victim to the presence of the intruder. The victim did not hear the back door slide open, nor did the victim hear the intruder walk across the kitchen, all of which is highly improbable.
So how firmly do you trust Mr. Van Owens' expertise?
Not at all. All anyone does in his position is read my reports. They never interact with the typical crime scene, and they misinterpret CSR evidence to draw their own convoluted theories. Essentially, Van Owens was only brought in to dismiss my correct theory.
And one last question. In your expert opinion, who can you conclude is responsible for this crime?
In my expert opinion, based off of all the evidence collected at the crime scene, including the ring security footage which captured the perpetrator's height and build, those height and build roughly match that of the defendant, and therefore I believe beyond a reasonable doubt that Miss Becker or Mr. Becker is the defendant that is responsible for the murder of Mr. Brackman.
Objection, speculation.
Again, she's indicated that this is her theory. As a consequence, it's not speculation, it's offered only as a theory and an opinion. So your objection is overruled.
Your Honor, I am sorry. I said the wrong objection. What I meant to say was the witness is speaking upon opinion of the underlying matter of the case.
Well, she is offering her opinion as to the ultimate outcome of the case. I'm going to find that your objection was untimely made. So again, I'm going to overrule the objection, and you obviously can cross her on as to the basis to support her opinion on cross-examination. So the objection is overruled.
Thank you, Your Honor.
Thank you, Your Honor. No further questions.
All right, she's subject to your cross-examination now, Ms. Merritt.
Thank you, Your Honor. Ms. Kuzak, you testified that you have two key principles that guide your work, right?
I'm sorry, could you repeat the question or like make it a little bit louder?
You testified that you have two key principles that guide your work, correct?
Yes.
One of these two principles was assuming every case is going to trial, right?
Yes.
And the other one is memorializing, documenting, and organizing evidence with a mindset of future reconstruction, correct?
Correct.
Now, with a mindset of future reconstruction, what that means is that you're trying to be as detail-oriented as possible when investigating a case.
Yes.
And as a part of your memorializing and documenting the evidence, it's true that you are a witness information tracking sheet, isn't it?
I did.
You had 7 different witnesses that you identified in this case, right?
Yes, I did.
Isn't it also true that you identified 3 different suspects in this case?
I did.
One of the suspects is my client, Avery Becker.
I did.
The other one is Alex Cifuentes.
Yes.
The last one is Blair Rollins.
Yes.
Now, Ms. Kuzak, you testified earlier that one of your 3 suspects was Blair Rollins, right?
I'm not sure I mentioned Blair Rollins in my testimony.
This is beyond the scope of direct examination.
Okay, two different things are going on at once. One, Ms. Mertz, she's correct that she did not mention Blair Rollins on her direct examination, but it is cross-examination, and so she is able to ask questions as it relates to alternate suspects. So you simply need to rephrase your question, Ms. Mertz. Your objection is noted, Ms. Udeshi, but it is going to be overruled. She can ask about alternate suspects from this witness. Go ahead, Ms. Mertz.
Thank you, Your Honor. So moving on from that, Ms. Kuzak, Blair's name is not one of the 7 recorded on that witness information tracking sheet, right?
That is correct.
And isn't it true that if a name is not one of the 7 recorded, that you have no information on that suspect at all?
Yes, you can assume so.
So to clarify, you have 3 suspects in total.
Yes.
You only have information on 2 of them.
Yes.
And isn't it also true that no one has seen or heard from Blair since around the time of Brackman's death?
I cannot testify to that as that is beyond the scope of my statement.
But I'm sorry, let me rephrase my question. You do not know if Blair has contacted anyone since the time of Miss Brackman's death, right?
I wouldn't know. I did not analyze Blair that
This,
thoroughly.
this question is asking for speculation of my witness.
It's not asking for speculation. It's asking if she knows of any communications made by Blair subsequent to Mr. Brackman's death. She can answer that question. Go ahead.
I'm sorry, Your Honor.
Detective Kozak, or Ms. Kozak, are you aware of any contact with Blair since Mr. Brackman's death?
No.
Thank you. Ms. Maritz?
Thank you, Your Honor. So, Ms. Kuzak, you don't know where Blair Rollins was on the day of Mr. Brackman's death, do you?
No.
So Blair could have been at home when Mr. Brackman was killed, right?
It is possible.
Blair could have been at the mall when Mr. Brackman was killed, right?
That is also possible.
So, Ms. Kuzak, you do not know if Blair could have been at Mr. Brackman's house at the exact time Mr. Brackman was killed, do you?
I am not an expert in that, but I would say no.
Thank you. No further questions, Your Honor.
Any redirect examination, Ms. Udesh?
No redirect, Your Honor.
All right, thank you. Then this witness may be excused. The prosecution's next witness, please.
Yes, Your Honor. At this time, the prosecution would like to call Alex Cifuentes to the stand.
Okay. Mr. Cifuentes, you've been previously sworn, and you may proceed, Ms. McDonald.
Yes, Your Honor. Thank you. Could you please state your name, spelling the last for the record?
Yes, my name is Alex Cifuentes, Sifuentes.
And can you tell me a little bit about yourself?
Yeah, so I'm a senior at Colorado High School, CHS.
Yeah, and how would you characterize your involvement in today's case?
Well, I was a member of the CHS mock trial team with the defendant and my personal friend, Avery Becker, and another witness in this case, Taylor Perkins. Mr. Brackman was our amazing coach. I just still cannot believe that he's dead.
I'm sorry to hear that. Can you tell me a little bit more about Mr. Brackman?
Well, he was a fantastic litigator. Like, he was probably the best. He was always trying to find ways to improve our team, and he really cared about us and wanted to help. He actually represented a Colorado high school student's father during a trial before.
Mm-hmm. And, how is he helping your team prepare?
Oh, he stressed the importance of hard work and preparation. Although that meant Avery and he didn't really get along that well.
Could you elaborate on what you witnessed between Avery and Mr. Brackman?
Yeah, so Mr. Brackman was always trying to tell Avery to prepare better for practice and tournaments, and it really stressed the team out when Avery would just refuse.
Mm-hmm. And after those conversations, what happened?
Well, Avery seemed to hate Mr. Brackman for giving her some honest advice and always played the victim.
Mm-hmm. And did you witness anything else about their relationship?
Yeah, so their boiling point was pretty intense. Avery was demoted to the B team after being late to practice again. But then Avery convinced their friend Taylor Perkins to quit the team, which forced Mr. Brackman to bring Avery back into the A team.
How did you and your team react?
We were all pretty upset. Changes like this for a competition can really mess up the vibe of the team, And Avery did end up winning Best Attorney and Best Closing argument at regionals, but that just made the team even more mad.
And I'm asking about you specifically here. How did you feel about it?
I mean, I was a little mad. It's pretty frustrating when someone works real hard and someone else is just able to coast by. I mean, I know the scoring system isn't, you can go ahead.
Oh, I'm so sorry. Well, so I was just curious about how Mr. Brackman responded to Avery's win.
Well, during the next practice, Mr. Brackman tried to explain that good lawyers prepare for court and work hard, essentially saying that Avery shouldn't confuse good showmanship with good lawyering.
How did that go over?
Oh man, Avery was furious. Like as mad as I've ever seen anyone. He left practice like insanely angry. And as he left campus, he vandalized Mr. Brackman's admittedly pretty sweet ride by writing worst attorney award across the hood of his car.
That sounds strange. Could that have been an accident?
There is no way that was an accident. Like, I watched Avery grab a Sharpie from the easel of paper. It was not a dry erase marker, and as everyone knows, they don't look the same at all.
Mm-hmm. So what did Mr. Brackman do about this?
Well, I personally thought Mr. Brackman should have pressed criminal charges, but he was a caring coach and really did want to help us. He did remove Avery from the team, which puts us in a pretty bad situation for state. As I said, changes like this big before competition can really mess up the vibe of the team.
Mm-hmm. And so what happened after Avery was removed from the team?
Well, Avery texted me shortly after that whole vandalism incident and asked that I talk to Mr. Brackman for him. He wanted me to convince Mr. Brackman to let him back onto the team.
Mm-hmm. So did you approach Mr. Brackman?
I did, but Mr. Brackman did not seem interested in letting Avery back on the team, which is reasonable.
So then how did Avery respond to that?
Oh, she was again furious. This might be the second angriest I've ever seen her. And she texted me some pretty interesting things.
You took screenshots of that exchange, correct?
I did.
If I showed you those screenshots, would you recognize them?
Yeah, I would.
Your Honor, at this time, I move to have co-counsel present what has previously been marked as Exhibit 14.
You may.
Thank you, Your Honor. Could you tell me a little bit about this exhibit?
Yeah, so these are text messages that were sent between me and Avery.
And how do you know that?
Objection, Your Honor.
I'm sorry, I didn't hear.
Objection, Your Honor, hearsay.
Okay. Mr. Blas is objecting based on hearsay. And Ms. McDonald, your response?
Yes, Your Honor. Under Rule 801D2, this is an opposing party statement, and therefore we can use this in trial today, and Ms. Becker may testify to the veracity of these screenshots at a later time.
And Mr. Blas, any response?
Yes, Your Honor. This is hearsay because the declarant did not make this while testifying at the current trial or hearing. And it does not prove the truth of the matter asserted in the statement. This statement is a written assertion or nonverbal conduct.
All right. I'm going to overrule your objection under hearsay. Under 801, I believe it's D2, it would not constitute hearsay as it is a statement by a party opponent to the action. Also, again, whether or not it's offered for the truth of the matter asserted is a foundational element that hasn't been addressed yet. So I'm going to go ahead and overrule the objection. I'll allow Ms. McDonald to continue the examination with regard to what's been marked for identification purposes only at this point, People's Exhibit 14. You may continue, Ms. McDonald.
Yes, Your Honor. Is this a clear and accurate representation of the text that you received from Ms. Becker?
Yes, it is.
Your Honor, at this time, I do move to have this exhibit entered into evidence.
All right. It's now been moved to be admitted. Mr. Blas, I'm assuming you have the same objection?
Yes, Your Honor, and objection to authentication.
All right. Well, the document purports to be texts from the defendant. Again, they simply purport to be that. I don't believe that anybody is suggesting that they're anything more than purported text messages from the defendant in this case. So since they don't constitute hearsay under 801, and the witnesses identify them as true and accurate representations of the text that he received, I'm going to admit them for that limited purpose. I'll note your objection. Your objection's preserved, but the People's Exhibit 14 is admitted. You may proceed, Ms. McDonald.
Yes, Your Honor. So could you tell me a little bit about what is stated in the later parts of these texts?
Yes, I can. So in the later parts of these texts, I tell Avery, or after I tell Avery that I tried to get her back onto the, or him back onto the team, he says this: well, if he, talking about Mr. Brackman, is still upset about his car, he's really gonna be upset when he sees what I do to his house. And I ask, what are you gonna do to his house? And then he says this: I'm gonna break in while he's at work, and he says I'm gonna wait till he's at work and then break in the trash.
Excuse me, Mr. Blas is voicing an objection. If you could hold on for just a second, Mr. Cifuentes. Mr. Blas, your objection?
Yes, Your Honor, hearsay.
Okay, again, if Mr. Cifuentes is simply limiting himself to repeat what's contained in People's Exhibit 14, it is admissible as an exception to hearsay, but also I believe the document speaks for itself. So Ms. McDonald, you wish to have Mr. Cifuentes tell us what is already admitted on the text or simply show the text? It's up to you.
Sorry, so Your Honor, he is currently quoting the text verbatim, but I can have co-counsel present again if you would prefer that.
Well, it's your choice. I mean, we don't need both. Either he's going to say it or we're going to read it, one or the other.
Mr. Cifuentes is going to continue with his testimony without the exhibit.
All right, thank you. You may continue, Ms. McDonald.
Thank you, Your Honor. So you were saying that Avery had been talking about what he was going to do to Mr. Brackman's house. Can you continue that?
Yes. So he says, I'm gonna wait till he's at work and then break in and trash it. He says that'll show him.
How did you feel about this?
Well, I didn't think it was a good idea, and Avery went to Mr. Brackman's house and murdered him.
No further questions, Your Honor.
All right, thank you. Mr. Blas, cross-examination.
Yes, Your Honor. Good morning, Mr. Cifuentes.
Good morning.
You claim that Avery Becker and you are good friends. Is this true?
Yes, we're best friends.
But you admit that you only spend time together at mock trial and related events, right?
We can still be best friends if we only spend time at mock trial together.
Today you testified to some things that bothered you about Avery, didn't you?
What specifically are you referring to?
Mr. Cifuentes, are you testifying today to some things that are bothering you about Avery?
I asked you what specifically you want me to answer about.
I'll move on. You thought you should have won the award, didn't you? Specifically the Best Attorney Award.
Yes, I personally thought that was a very good attorney, but the scoring system is flawed, so one judge may enjoy a performance better than the other one and score that performance higher.
Thank you. You even told Mr. Brackman that he shouldn't put up with Avery's behavior, didn't you?
It really messed up the vibe of the team whenever he would not show up to practice on time or prepare.
You say all this despite claiming to be such good friends with Avery.
I mean, friends can call each other out. That's what friends are sometimes for. Like, sometimes you guys just gotta call out your friends, you know?
After Avery vandalized Coach Brackman's car, you said that Avery asked you to speak to Mr. Brackman to let him back on the team, correct?
Yes, because we are such great friends. He texted me.
But you thought Mr. Brackman should have pressed charges against Avery for the vandalism, didn't you?
I did testify to that, but since he is such a great coach, he did not.
When Avery asked you to speak to Mr. Brackman to help him get back on the team, you considered not approaching Mr. Brackman so that you could get a better position on the mock trial team in Avery's absence, didn't you?
I believe I considered that for maybe a second, but I did end up approaching Mr. Brackman as Avery is my best friend.
So that's a yes?
I did testify that, yes.
You even told Avery to forget about the trial team and move on, didn't you?
Well, I mean, yeah, he was taken off the team, and Mr. Brackman was not going to let him back on.
Personally, you really like Coach Brackman, right?
Yeah, Mr. Brackman was a great attorney and a fantastic coach.
Thank you. You also assert that you would never have done anything to put Coach Brackman in danger, right?
That is correct.
But no one has explicitly accused you of doing so, have they?
No, because I didn't do anything.
No one's saying you did anything. Despite this, are you apparently concerned that others think you had something to do with Coach Brackman's death?
Objection, Your Honor. This is both argumentative. It's also outside of the scope of the witness's knowledge. He doesn't know whether or not people are blaming him for anything.
I'm not going to speculate as to what he does or doesn't know, but if he's aware of whether or not other people are blaming him for anything and it's having an impact on him, it certainly makes it relevant. So yeah, I'm going to note your objection, but I'll overrule it. And Mr. Cifuentes, again, if you know the answer, please provide Mr. Bloss with the answer to the question. Objections overruled.
Yes, sure.
Thank you, Your Honor. Would you like me to repeat the question, Mr. Cifuentes?
Yeah, I would.
Despite this, are you apparently concerned that others think you had something to do with Coach Brackman's death?
I believe I was, as other experts on my side did testify to, I was interviewed, but I'm 100% sure that they have ruled me out.
Thank you. You saw Avery and Taylor at the Fry Shack on the night before Coach Brackman was murdered, didn't you?
I believe that well, I saw Avery many times at the Fry Shack.
Avery even let you use his phone to play a game that night, right?
That was not the night for the murder. That was a different time that I testified to in my statement.
But he did let you play a game on his phone?
That was a different instance. That was a different to the Fry Shack than the one before the night for the murder. But yeah, there was one point where he did, yes.
Yeah, so that's a yes?
Yes.
Later, you provided the police with suspicious text messages that Avery had supposedly sent to you, didn't you?
I would not call those text messages suspicious, and those are text messages that Avery sent to me.
The police wanted to see your phone. Is this true?
I don't think the police ever asked to see my phone. I don't think that they felt like it was necessary because they trusted me so much.
You didn't have it on you, right?
It was going dead. It was charging. You know, the stress of being interviewed by a police officer just kind of gets to you sometimes.
Because of this, you emailed screenshots instead of providing your actual phone, right?
I did, and the police accepted those as true.
These screenshots were never verified with the actual phone, were they?
No, I had to trade in my phone. I would have if they would have asked me.
For the jury's time, you can talk to your own attorney about this in redirect. Here, for the sake of the jury's time, please answer yes or no. They cannot be verified because you don't even know where the phone is, correct?
That is correct.
You are accused of faking the screenshots you provided to the police, right?
Yeah, I think I am aware of that accusation.
So that's a yes.
I'm aware of that accusation.
Avery also accused you of stealing his phone and giving it to Blair, right?
I think I'm also aware of that accusation, yes.
So that's a yes.
Yes.
But you do know Blair Rollins, don't you?
No, I wouldn't know him well enough to say hello or goodbye in the house.
Thank you, Your Honor. I have no further questions for this witness.
Thank you. Ms. McDonald, any redirect examination?
May I conduct a brief redirect, Your Honor?
You may.
Mr. Cifuentes, why are you here testifying today?
I am here because I want justice for my dearly departed coach.
And would you lie here today?
I would not lie here today.
No further questions, Your Honor.
Thank you. This witness may be excused.
And
Does
at
the
this,
Go ahead.
I'm so sorry, Your Honor. At this time, the prosecution rests.
All right, thank you. The defense, if you would call your first witness, please.
Yes, Your Honor. The defense calls Taylor Perkins to the stand.
And Taylor Perkins, if you would unmute. And you are under oath. Mr. Blas, you may proceed.
Thank you, Your Honor. Good morning, Ms. Perkins. Can you please state your full name and spell your last name for the record?
Yes, good morning. My name is Good morning. My name is Taylor Perkins, Perkins.
Thank you. And what is your occupation?
Currently, I'm just a student at CU Boulder.
What is your relationship with Avery Becker?
Avery is my best friend. I've known him since high school.
In high school, what did you and Avery do together typically?
Well, we did mock trial together, as well as going to mall and hanging out at the price rack.
What was Avery's reputation as a participant in mock trial?
Well, he was a good mock trial team member. He was known as one of the best lawyers on the team, and he just did really good.
How well did Avery get along with your other teammates?
It was rocky at times. You know, like I said, he's very good at being an attorney, and some people didn't appreciate it at times. People like Alex Fuentes.
So how would you describe your teammate Alex?
Well, from what I've seen of him, you know, at practices, he seems to really be after what Avery, Avery gets a lot of roles, right? Alex is always striving to be better than Avery, and to me, he seems slightly jealous of Avery's accomplishments.
Where were you on the night of March 5th?
That night, Avery had come over to my house, and we had gone to the fry shack.
What did you do after he came over?
Well, we played some games, and then we got hungry, so like I said, we went to the fry shack, and there we actually saw the mock trial team. Well, the mock trial team had showed up right after their practice, and Alex was there, and we were all talking, you know, just chatting at a table. Alex actually doesn't have that good of a relationship with Avery, so Avery wanted to distance himself a little. So he went to the bathroom to get some, space. And I stayed at the table talking with Alex. At the time, Avery's phone was actually on the table. And then when Avery came back from the bathroom, we went to the mall together.
What other interactions did you have with Alex at the Fresh Shack?
Sorry, can you rephrase that question?
What other interactions did you have at the Fresh Shack?
Well, Alex was there. We did speak about how Avery, because at the time Avery had been kicked off the team, we were all, speaking about that, and how it was pretty unfair that Coach had kicked off Avery and that he didn't even want to talk to him anymore. You know, Avery did want to fix things and talk things through, but Coach just didn't let him.
Where were you the next day on March 6th?
That whole day I was with Avery. We were actually looking for his phone, which he had lost the day prior.
Do you have any idea about how Avery lost his phone?
Well, I do vaguely remember at the Fry Shack his phone.
Objection.
You know, it was
This witness is speculating on what happened to Avery's phone.
Well, I believe her answer was about what she remembered from the day before. So I don't think that's necessarily speculation. I'll note your objection, but I'll overrule it. You may answer that question.
Thank you, Your
Ms.
Honor.
Perkins.
well, I do remember his phone was sitting at the table. That was the last time I actually saw it. So I do think he lost it there at the Fry Shack. It's a possibility that someone stole it or that it was just left there.
How did Alex react to Avery getting kicked off the team?
Well,
Your Honor,
I'm sorry.
how would the witness know how Alex reacted to Avery getting kicked off the team?
Well, the witness would have to have observed Alex's reaction to Avery being kicked off the team. Otherwise, that does call for speculation. Mr. Blas, if you'll lay a little bit of foundation as to how the witness might know that information, then we'll proceed with that question.
Thank you, Your Honor.
Yes, Your Honor. I'll just move on, Your Honor. Thank you, though. When did you learn that Avery lost his phone?
I learned that March 6th in the morning when he came to pick me up from school. To give me a ride to school. It was at that time also that we decided to skip school to look for his phone.
Where did you look for the phone?
Well, we went to the mall to retrace our steps. We went to all the stores to look for it, and we couldn't find it there. So our last stop was the Fry Shack since we had been there the day prior, and so we went there to look for it.
Did you ever find Avery's phone?
No, actually, we very thoroughly looked, but we could not find it.
I'm sorry, Ms. Udis, you're going to have to speak much louder if you want to voice an objection, or start with the word objection. That'll draw my attention.
Objection, Your Honor. That was a leading question.
All right, I'm going to have Mr. Blas repeat the question then.
Did you ever find Avery's phone?
Yeah, that's not a leading question. So your objection's overruled. Go ahead, Ms. Perkins, could you go ahead and respond to that?
Yes, as I was saying, we actually couldn't find it. We did look everywhere. We retraced our steps. We couldn't find it.
Then what happened? You mentioned you were at the Fry Shack. Then what happened there?
Well, actually, something pretty surprising happened. We went there to look for the phone, and we ran into the mock trial team. It was surprising because they were supposed to be in practice at the time. That is when we found out that Coach Brackman never showed up to practice.
So we've heard some testimonies today that Avery and Coach Brackman had a disagreement. Do you know anyone else that could have had something against your coach?
Well, the only person that comes to mind is Blair Rollins.
Why do you say Blair Rollins?
Well, Mr. Brackman was actually the person that put Blair Rollins' dad in jail after losing a case. And if my dad was put in jail for such a long time because of a specific person, I would be angry at that person.
So what was Mr. Blair Rollins' reputation at school?
His reputation at school wasn't that good. He was known as a very strange kid. People would say that he's the type of person that could kill someone and not feel bad about it, which is kind of scary. I feel like that might be why he and Alex were friends.
Finally, would you lie for Avery?
No, I wouldn't lie for Avery, especially about something this serious. this is something that is just horrible. It's such a bad, sad thing, you know. And I have known Avery for such a long time. I just don't think he's capable of murder.
Thank you, Your Honor. I have no further questions for this witness.
Thank you. Ms. Yudish?
May I proceed with my cross-examination, Your Honor?
Yes.
Thank you, Your Honor. So, Ms. Perkins, I hope you're ready to answer some questions about this case.
Yes.
I'd just like to ask you that you keep your answers short and concise, just for the jury's time. Starting off, you testified that you were Avery's best friend.
Yes.
And that you really valued his friendship.
Yeah.
That you've known him for a really long time.
Yes, I have.
Joined a lot of extracurriculars, just like mock trial for Avery.
Well, it was just mock trial. It's the only extracurricular I joined.
So you joined the mock trial team just for Avery?
Yeah, I wanted to hang out with him. It's a good time to bond.
You would do almost anything to keep that relationship going?
I don't understand your question.
Do you really value this relationship to the extent to do almost anything to keep this relationship going?
Objection, Your Honor, speculation.
No, she's not. The question isn't asking for her to speculate. The question is to ask her about whether or not she would, I think, ultimately say, are you willing to lie to keep your friendship with Mr. Becker in a roundabout way? Ms. Udeshi, is that where you're going?
Yes, Your Honor.
Then ask that question.
Would you, would you be willing to lie to keep this relationship going?
No, I mean, we are good friends and I do support him, but I wouldn't lie for him, especially about something this serious, like I said earlier.
Thank you. So you heard about how Coach Brackman was critiquing Avery at practice?
Yes, I did.
But you only heard that through Avery's perspective.
Well, I heard it from Avery, so yeah.
So Avery decided that the best thing to do was write on his car with an alleged whiteboard erase marker?
That's what happened, yeah.
But, and Avery said that he did this because he was angry at Coach Brackman for his statements and wanted to freak him out?
Yeah.
And this did cause property damage and the paint was ruined on the car.
Well, yeah, and for that, he was very sorry. At the time, he actually really did think it was a dry erase marker. It was just a freak accident.
Thank you, Ms. Perkins. So Avery thought that vandalism, an actual crime, was a good way to get back at Coach for his statements.
Like I said, he genuinely thought it was a dry erase marker.
Is that a yes or a no, Ms. Perkins?
Can you repeat the question?
So Avery thought that vandalism, a crime, was a good way to get back at Coach for his statements?
Well, no, it was just kind of something that happened, you know?
So the final outcome of his decision was to commit a crime.
Like I said, it was a dry erase marker, or that's what he thought it was. It was really an accident.
But this was the final outcome of the decision? Property damage? Vandalism?
Yeah, that's what ended up happening.
Thank you. So Coach Brackman did kick Avery off the team for this?
Yeah, he did.
And did this hurt Avery's feelings?
Well, yeah, he really liked Montreal. It was a big passion of his. He was sad to be, away from the team.
And you believe Avery texted everybody on the team, including Alex Cifuentes?
Yeah, I mean, he was that, desperate. He doesn't like it, Alex, but he was really trying to get back on. He was really sorry about what happened. He really regretted it, and he just really wanted to go back to the team.
So you remember the day when Avery got kicked off the team, correct?
Yes, I do.
And you guys went to the Fry Shack after that practice?
Wait, can you repeat the last question?
You guys did go to the fry shack after Avery got kicked off the team, that practice?
He was kicked off prior to when we went to the fry shack. That day he was just, coach just didn't want to talk to him. So after that, he came to my house and we just hung out, and then we went to the fry shack.
Yes, that is what I was insinuating. And did you guys talk about how unfair it was that Avery was kicked off the team, like with your mock trial members?
Yeah, all the teammates, they were coming up because they had all talked to Coach Bracken about it. They were all saying how unfair it was.
And that day, Avery stormed off to the bathroom after talking to Alex Cifuentes.
Well, I wouldn't say stormed off, but yes, he wanted to get some space between him and Alex.
And she didn't grab her phone after that encounter? She left it on the table?
Yeah, he left his phone on the table.
And do you actually fully remember this incident?
Well, I remember it enough. I mean, everybody forgets things, but
Ms. Perkins, can you be fully 100% sure that Avery left his phone on the table?
No, I mean, nothing is 100%.
So do you remember the day that you did school to look for Avery's phone?
Yes.
And in the whole day, neither of you remembered you could use Find My iPhone to find Avery's phone?
No, well, actually, I have a Samsung and he has an iPhone, so it wasn't really possible. I did call him several times though. Nobody picked up.
And can we go back briefly to the day Avery vandalized Brackman's car? He was pretty rash during that decision, as you described it.
Well, yeah, I guess.
And so Avery could have wanted to go further than vandalism when he actually kicked her off the team.
I don't understand your question.
Your Honor. No further questions.
Okay, well, I guess we'll never hear the answer to the question. Any redirect examination, Mr. Block?
No redirect, Your Honor. Thank you.
Thank you. This witness may be excused. If the defense will call their next witness.
Your Honor, the defense calls Blake Van Owen to the stand. And
Thank you.
Before we proceed, could I please ask for a brief time check?
Sure.
The defense has 7 minutes, 49 seconds.
18 minutes?
17 minutes.
17 minutes. Thank you. Okay. Good evening. Could you please state your name for the record?
Good morning. My name is Blake Van Owen.
Good morning. Mr. Van Owen, I am going to ask you first about your expertise. What is your role with respect to the case?
I was hired by the lawyers of Avery Becker to conduct my own partial investigation into this case and give my expert opinion on this case.
Have you ever testified as an expert in court?
I have several times.
In what areas are you regularly qualified to provide testimony as an expert?
I have been admitted as an expert in crime scene reconstruction 8 times, as a cell phone tower analysis in 5 cases, and general police practices 12 times.
Which courts have qualified you as an expert in these 3 areas?
I've been admitted in the district courts of Colorado, Kansas, and Arizona, and the state courts of Colorado, Wyoming, Nebraska, and New Mexico.
What did these courts rely on in order to admit your expert testimony?
They relied on my education as well as my hands-on experience with my work with crime scene reconstruction and cell phone tower analysis.
What is your educational background?
I received my bachelor's degree from CU Boulder in 2005 in English, and my master's degree in criminal justice from Ashford University in 2014.
Please describe your professional career.
In 2005, I worked for the Aurora Police Department for 9 months, and then I went into private investigation. And through this time, I have taught a class on police procedures, at Colorado School of the Rockies, and I've taught a class at CU Denver on police procedures.
Your Honor, at this time, I would move to admit Mr. Blake Van Owen as an expert in crime scene reconstruction, cell tower record analysis, and general police investigation tactics.
Thank you. Ms. McDonald, the position of the prosecution?
Yes, Your Honor. Could I conduct a brief ordeer?
You may.
Thank you, Your Honor. May I begin?
Yes.
Just to discuss your experience a little bit, you were only a police officer for less than a year, correct?
That's correct.
Because of an incident in which you injured someone during an arrest?
Right, but I was cleared of all wrongdoing by the police department.
Well, you had mentioned that you never cleared yourself of wrongdoing. Is that correct?
That's right. I did say that.
And this was in 2005 that you were a police officer?
Right.
So that's 16 years ago?
Using basic math, yes, you could say that.
Great. So, Your Honor, at this time, due to Mr. Van Owen's record, I would like to limit the scope of his expertise to not include police investigation tactics, as he hasn't been an officer in 16 years. As well, he injured someone during his time as a police officer, and that does call into question his expertise.
Great. Thank you. Ms. Guadana, do you want to respond, or do you wish me just to rule?
I would wish to respond, Your Honor.
Go ahead.
Under Rule 702, it is specified that a witness can be qualified as an expert by knowledge, skill, and experience. And in this case, leaving from the force doesn't mean that he loses the experience. He also graduated with a master's degree in criminal justice, and he has testified that he is an instructor and teaches classes on police practices. This would include his knowledge about police practices and investigation techniques.
Thank you. All right. Under 702, any person based on their education, training, and experience who can add value to the determination of the evidence for the benefit of the jury can be deemed an expert. Again, the weight of their opinion is what the jurors need to decide, not its admissibility. So I'm going to go ahead and recognize Blake Van Owen as an expert in crime scene reconstruction, cell phone analysis, and general police activity. I would indicate that the fact that he may have injured somebody on the job is irrelevant to whether or not he's qualified to serve as an expert on these matters. Again, there's nothing to suggest that he was ever criminally charged or criminally convicted. And by his own testimony and his own admission, he was cleared of any wrongdoing by the police department's investigation. So I'm going to find that that bears no relevance on his qualifications as an expert. So your objection, Ms. McDonald, is noted. However, I will recognize him as an expert in all three fields. And Ms. Guadana, you may continue.
Yes, Your Honor.
Thank you, Your Honor. Let's talk about your professional opinions in this case. What is your opinion about the investigation conducted by Detective Markowitz?
I believe that it is incomplete, rushed, and inaccurate.
Why do you say that?
Well, first, Detective Markowitz lost evidence. He lost pictures of blood spatter, a digital file that was mysteriously corrupted, and I mean, lost evidence is just not good. And I mean, any halfway competent police department would keep more than one copy of these photos.
How else was this investigation flawed?
Well, it was also flawed by Detective Markowitz when he didn't verify alleged text messages between Alex Cifuentes and Avery Becker. All he had to do was get the phone and verify the text messages, but he didn't do that in this case.
Thank you. Next, let's talk about the police's failure to investigate any other suspects. Earlier, you said the investigation was incomplete. Why is that?
I believe that it was incomplete because there was no investigation of other suspects, such as Blair Rollins, for example.
What do you mean never investigated?
Well, I mean, Detective Markowitz even said that a disgruntled ex-client should be looked into, but neither him or Kyle Kuzak looked into this further.
Did you investigate Blair Rollins?
I did.
What did you do specifically?
Well, I listened to a related trial recording where I found out that one of Mr. Brackman's ex-clients had been convicted of murder. His name is Jonathan Rollins, which is Blair Rollins' father. And this conviction took place a few months before Mr. Brackman's murder. And I wonder why the police didn't investigate Blair further.
We've talked about your opinions on the investigation. Now I'd like to talk to you about your opinions on Kyle Kuzak's crime scene reconstruction. Did you reach an opinion about her crime scene reconstruction?
I did. I had said that the evidence did not point in the direction that she went.
Why not?
Well, first and foremost, Detective Markowitz and Kyle Kuzak both made a huge deal about the ring app notifying Mr. Brackman that there was an intruder. But this is not as reliable for two reasons. The first reason being that neither Detective Markowitz or Kyle Kuzak received the complete user records for the phone of Mr. Brackman, which would have told us if the notifications were on or off. And two, even if the notifications were on, there's no evidence that would have told us that Mr. Brackman had seen the notification.
What is your expert opinion on how this crime was committed?
Well, my expert opinion is that whoever it was snuck up behind Brackman and stabbed him in the back and had used enough force to nick Mr. Brackman's aorta. And yeah.
Mr. Van Owen, can you show the jury what the motion of the knife stabbing would have had to look like in your professional opinion?
Sure.
Let the record reflect that Mr. Van Owen had his hands above his head and he was moving them downward as if from a higher position than the imaginary person he is stabbing. You've also been qualified as an expert in cell phone tower record analysis. Did you have any opinions about the location of Avery's cell phone on the day of Mr. Brackman's death?
I do. I believe that they show nothing about where Avery was. Instead, they show where Avery's phone was at. And even that is not 100% accurate. I believe instead that it is an alibi for Avery Becker.
What do you mean by only the location of the phone is shown?
Well, a cell phone is designed to get the best connection. And the best connection is not always the one that is closest to it. All that the antenna that had pinged closest to Mr. Brackman's residence, all it could have been was that it provided the best signal.
You mentioned call detail records. What call detail records are you referring to?
I was referring to the call detail records of Taylor Perkins.
And why are Taylor Perkins' call detail records important?
They are important because for every corresponding call from Avery's phone, there's another call from Taylor's phone. And this is important because it supports their alibi of looking for Mr. Becker's phone at the time.
No further questions, Your Honor.
Thank you. Cross-examination.
Yes, Your Honor. May I begin?
Yes.
So, Mr. Van Owen, you believe that Ms. Kuzak and Detective Markowitz came to an easy conclusion in today's trial, correct?
I do believe that.
And do you think that the easy conclusion can be correct sometimes?
I mean, what is that saying? Well, possibly, but again, it should have been investigated further.
Possibly. So you did come to your conclusions in today's trial based off of the findings of Detective Markowitz and Ms. Kuzak, correct?
I went off of what I had.
You used all the same evidence they presented today in court, correct?
You could say that. That's right.
Were you able to view the crime scene in today's trial?
I was not able to review the crime scene, only pictures of it.
Were you able to question any of your own suspects?
I tried to get an interview from Mr. Cifuentes, but he denied me, so I didn't get it.
Understandable. So Could you take a look at Exhibit 9 for a second?
Can you pull it up?
I can try to. So were you able to view this picture of what you purport the crime scene to be, that chair, correct?
Right.
And you purport
Excuse me, Ms.
that.
McDonald.
Mhm.
I have People's Exhibit number 9 as a photograph of a broken plate.
Yes, there is a chair also in that photo.
Oh, okay, go ahead then. I'm sorry.
I'm so sorry, I should have been more clear. So you purport that Mr. Brockman was in the seated position when he was stabbed, correct?
I did opine that in my report.
And that he was stabbed through the aorta, correct?
Right, in a downward motion.
Right, that would produce a lot of blood, correct?
Right, as seen in the blood pool in exhibit, in the picture of him.
Right, but in the seated position, he would have been seated at one of those chairs that is in Exhibit 9, correct?
I'm sorry, could you repeat, rephrase the question? I don't understand what you're trying to
Absolutely. So you purport that he was in one of the chairs that are shown in Exhibit 9.
Right.
Do you see any blood splatter from that chair?
Right. No, but
No.
there were pictures that were corrupted and lost.
Right.
So
Well, I'm just asking about the crime scene itself. Did you question Jonathan Rollins in today's trial?
No, I could not.
Right. So you weren't able to contact Blair either, correct?
Yeah, that's right. And neither did Detective Markowitz or Kyle Kuzak, for that matter.
So no one was able to verify Blair Rollins's location at the time of the murder, correct?
That's right. Could have been anywhere.
And you mentioned during direct examination that you thought that Detective Markowitz and Ms. Kuzak didn't investigate any other suspects. Are you aware of Ms. Kuzak's finding in today's trial?
Yes.
And you do know that in her initial report, she did mention 3 potential suspects, correct?
Right, and she only had information on 2 of them.
Right. She wasn't able to find Blair Rollins. Understandable, correct?
That's understandable.
But she did look into other suspects.
Only the 2 that were out of 3.
Right. And according to the pay that you receive in today's trial, you only worked 31 hours in this investigation.
That's right. That was only what I was paid for.
Right. So that's less than the minimum of 40 hours a week most general jobs and positions require.
Yeah, you could say that.
So, So in your investigation, you were unable to collect any of your own evidence.
You could say that.
And you were unable to verify any of your theories, correct?
I'm sorry, could you, I don't understand what you're trying to say.
Sure. You weren't
Sorry.
able to then verify any of your theories that you presented today, correct?
You could say that.
They're merely assumptions, correct?
I think that Kyle Kuzak's opinion was an assumption.
Right, but did you have any evidence supporting your theories today?
I had the same evidence that Kyle Kuzak did.
Right, you misinterpreted the same evidence that they brought today, correct?
I wouldn't say that I misinterpreted it. I only gave my
You
opinion.
base your conclusions off of the evidence presented today.
That's right.
No further questions, Your Honor.
Thank you. Any redirect examination, Ms. Guardana?
No, Your Honor.
All right, thank you. Witness is excused. The defense may call their next witness.
Thank you, Your Honor.
The defense calls Avery Becker to the stand.
Avery Becker, you're under oath,
Yes, Your Honor.
and you may proceed, Ms. Maris.
Could you please state and spell your name for the jury?
Avery Becker, Averybecker.
Mr. Becker, you're the defendant in this case. And testify.
I'm here because I'm being unfairly accused of murder, and I want to tell my side of the story.
Before you're accused, can you tell me like as a high school student?
Yeah, I usually hang out with my best friend Taylor Perkins. We did mock trial together, and we usually go to the Fry Shack and hang out at the mall.
Did you know Mackenzie Brackman?
Yeah, he was my mock trial coach.
How would you describe your relationship with Mr.
We had a tense relationship. We didn't always get along, and I really always didn't agree with everything he said.
How did you feel about Mr. Brackman?
Although we had our differences, I thought he was a great coach, and I respected how he could bring the mock trial team out on top.
How do you feel about his death?
I feel horrible. I feel terrible that we had a back and forth relationship, and I never really got to apologize to him for what I did.
What did you feel you had to apologize?
Well, after the tournament, we were going over the good and bad things that we did.
Excuse me. Ms. Gutierrez, do you have an objection?
Speculation.
I'm sorry, what was the objection?
Speculation.
For some reason, I'm not able to hear Ms. Gutierrez. And Ms. Maris, I'm getting an echo from your device. Do you have two microphones going?
I think it's coming from Avery Becker's room.
Mr. Becker, do you have two microphones on?
No, Your Honor. I only have the microphone from the camera I'm using.
Can you please do me a favor? Mute your.
Sorry? I couldn't really hear.
Mr. Diaz, please mute your mic and unmute only to speak. I believe your speakers are turned up too loud.
Okay.
All right.
Is that better?
All right.
That's
Ms.
a little
Gutierrez,
better, but
did you have
please
an
remain
objection?
muted unless you're speaking.
Okay.
Yes, I had an objection for speculation, Your Honor.
All right. And Ms. Maris, I hate to do this to you, but could you go back and repeat your question?
My question was, what did you feel you had to apologize for?
That's not calling for speculation. So your objection's overruled.
I recall, Your Honor, she said, "What did you think?" But
I'm sorry. Go repeat it again, Ms. Gutierrez.
As I recall, Your Honor, the attorney mayors had said, "What did you think you had to apologize for?" But
yeah, no, he can still answer that question. Your objection is noted and overruled. Okay, and Mr. Becker, can you go ahead and tell us what you believed you had to apologize for?
Yeah, after the tournament, we were going over the good and bad things, and Coach Brackman was saying some things that made me a little upset. So I stormed off with the marker still in my hand, and I later found out that it was a permanent marker, and I wrote Worst Attorney Award on the hood of his car.
I think it was.
Go ahead, Ms. Maris.
Can you guys hear me?
Yes.
Okay, I'm sorry. Mr. Becker, what kind of marker did you think it was?
I thought it was a dry erase marker since we were writing on the whiteboard, but it turns out it was a Sharpie.
And you mentioned that you wrote Worst Attorney Award. Why would you write that?
Well, a while back, Coach Brackman lost a big case, and I guess I hit a nerve or something. It was a stupid and awful thing for me to do, and I feel terrible about it.
Did you try to communicate this with your coach?
Yeah, I tried texting my coach. I offered to get a job so I could repair his car, and I also offered to scrub off the marker, but he didn't reply. He ignored me.
Did you try anything else to apologize to Mr. Brackman?
Yeah, I went to his office and I spoke with his secretary, but she said that he was busy, so I couldn't apologize face to face with him.
Now moving on, Mr. Becker, to the day before Mr. Brackman's death. Do you remember what you were doing on that day?
Yeah, me and my friend Taylor Perkins, we went to the Fry Shack.
Anywhere else that day?
Yeah, we also went to the mall after.
Did you and Taylor happen to see anyone else while you were out?
Yeah, we saw a lot of people from the mock trial team, including Alex Fuentes.
You mentioned Alex specifically. Why is that?
Well, Alex has said some things that made me a bit upset, so I went to the bathroom to cool off, and I left my phone there.
How long were you in the bathroom?
Just long enough for me to cool down.
What did you do after you came back from the bathroom?
Me and Taylor left right after that.
How would you describe your relationship with Alex generally?
We didn't have a good relationship, I would say. I mean, he pretends like we were best friends, but actually, I wasn't really friends with Alex Fuentes. He was more friends with Blair Rollins.
Moving on to the day of Mr. Brackman's death, what was the first thing that you remember from that day?
I couldn't find my phone.
Did you do anything about it?
Yeah, me and Taylor skipped school to go look for it.
Where was the first place you went?
We went to the Fry Shack.
Did you go anywhere else?
Yeah, we also went to the mall to go look for my phone.
Now, why did you go to these specific places?
They were the places that we were the day before I lost my phone.
Did you find it at either of those places?
No, I didn't.
Did you continue to look?
No, we unfortunately ran out of places to look.
Now, Mr. Becker, did you have your phone at all on the day of Mr. Brackman's death?
No, I didn't.
Moving on. Earlier in testimony, you mentioned that Alex was closer with Blair than Alex was with you. Were you and Blair friends at all?
Not really. I mean, Blair was a little weird. He would be the person most likely to become a sociopath, or him, and like as a joke.
Did you describe Blair's physical appearance?
Well, like me, we had the same body build and height.
Do you happen to know if Blair knew Mr. Brackman since they weren't on the mock trial team?
Yeah, Blair knew Mr. Brackman. Mr. Brackman was the attorney in charge of Blair's father's case, and he ended up losing the case that sent Blair's father to life in prison for murder. And yeah.
Do you know if this made Blair upset?
Your Honor, objection, speculation.
Okay, the way she phrased the question is, do you know if this upset Blair? So as a preliminary matter, he would have to answer, yes, he does know, or no, he doesn't know. Mr. Becker, do you know if Blair was upset?
Well, I would be upset. I mean, who wouldn't be?
Not the question.
Losing a father is devastating.
That's not the question. The question is, do you
Yeah.
know if Blair was upset?
Yeah, he was upset.
All right. Go ahead, Ms. Merritt, your next question.
Thank
Your
you.
objection's overruled, Ms. Gutierrez.
Mr. Becker, do you happen to know where Blair is now?
No, Blair disappeared. And here I am on trial being accused of killing my mock trial coach. I mean, I'm in disbelief.
So, just to be clear, Mr. Becker, did you kill your mock trial coach, Mr. Brackman?
No, I did not. No one can actually believe that I would kill my coach over something so silly as mock trial. I mean, that's crazy.
Thank you, Your Honor. No more further questions for this witness.
Thank you. Cross-examination, Ms. Gutierrez.
All right, good morning, Mr. Becker. All right, so you were on the mock trial team all 4 years at Colorado High School, correct?
Yeah, that's correct.
All right, and you were on the A team, correct?
Yeah, for a while I was.
And while you were on the team, you and Mr. Brackman didn't particularly get along, correct?
Not really.
Was this because he thought you needed to work harder?
Yeah, he did think I needed to work harder.
Because you were just a natural at mock trial and you can just come up with stuff on the spot with no real planning behind it, right?
I was pretty good at mock trial. I would say so. Yeah.
So because of this, Mr. Brackman always criticized your work?
Yeah, I guess he did.
And Mr. Brackman liked you to be prepared with a script written out for competitions?
I'm sorry. Can you repeat that? I couldn't really hear.
And Mr. Brackman liked you to be prepared with a script written out for competitions?
Yeah, he did. He would do that for the team. And I guess it would work for the team, but I didn't really want to follow the scripts.
Right, so you would still go off script and say what came to you, correct? As you just stated?
Yeah, I would. Because I'm confident in myself for mock trial.
Right, all right. And if you hadn't gone off script, you probably wouldn't have won all those awards, right?
I don't know. I can't say for sure because I did go off script and I did win the awards, but I wouldn't know if I stayed on script if I would have won those awards.
Right, all right. And did this disobedience make you and Mr. Brackman argue a lot?
Yeah, I guess we did argue a lot.
All right, and I just want to clarify one more thing before we move on, Mr. Becker. Your friend, Taylor Perkins, is she also on the team with you?
Yeah, Taylor Perkins was also on the mock trial team.
All right, so next question. About a month before the regional tournament, did Mr. Brackman bump you down to the B team?
Yeah, unfortunately he did.
Okay, but you got your closest friend, Taylor Perkins, to quit so that you would be on the A team again, correct?
Yeah, you could say that, but I'm not sure if Taylor, like, yeah, I guess so.
I already answered the question. So
Sorry.
Can you say then that Miss Perkins would do anything for you if you asked them?
No, not everything.
All right, moving on. After regionals, then at a later.
Sorry.
Okay, sorry about the echo. After regionals, then at a later mock trial meeting, you were assigned to write the pros and cons of the event on the board, correct? As already established in direct examination.
Objection relevance.
Your Honor, I'm trying to lay the foundation for further questioning.
I'm going to overrule the objection. We've talked about the events after the meeting that led up to the vandalism of the car. So that's relevant. We'll go forward. Objections overruled.
And at practice that same night, Mr. Becker, did Mr. Brackman start to criticize and call you out in front of all your teammates?
Yeah, he was criticizing me, and I guess that made me a bit upset.
All right, and he even told you that you wouldn't fare well at state, correct?
Yeah, he said that.
unfortunately.
All right, and did you or did you not storm out of practice after that happened?
Yeah, I did. I mean, I was a bit upset that my mock trial coach was criticizing me the way he was.
And then you stormed out of practice. Oh no, I'm sorry. And then you took the permanent marker that was still in your hand and wrote worst attorney award on Brackman's call, correct, as already established in direct examination?
Yeah, I thought it was a dry erase, but I later found out it was a permanent marker. Like I said, I feel awful about it.
After this moment that you were officially kicked off the team through a confrontation with Mr. Brackman, correct?
Yeah, understandably, Coach Brackman kicked me off the team.
All right, and then you later went home and told your mom that you were kicked off the team, but forgot to mention that you vandalized Brackman's car. Isn't that right?
Objection relevant.
Yeah,
I'm going to overrule the objection. You may answer the question, Mr. Diaz.
I'll restate the
sorry,
question.
can you repeat the question?
Yes, I will restate it for you. You later went home and told your mom that you were kicked off the team, but forgot to mention that you vandalized Brackman's car. Isn't that right?
Yeah, I was so upset. I mean, mock trial was something that I enjoyed doing, and I was crying on my mom's shoulder.
Right, and after this, you said you would put Brackman back if it was the last thing you did, correct?
I said that while I was kind of angry, but I wouldn't actually go through with it.
All right, moving on. The day before Mr. Brackman's murder being March 4th, did you go to the Fry Shack after school?
Sorry, can you repeat that? I can't really hear.
The day before Mr. Brackman's murder being March 5th, did you go to the Fry Shack after school?
Yeah, I did.
With Miss Perkins?
Mm-hmm.
And while you were at the Fry Shack, you had your phone with you, correct?
At the Fry Shack, I did have my phone.
And as I recall, you then went to the mall, correct?
Uh-huh.
But not once did you realize your phone was missing?
Not really, no.
And then on March 6th, you ditched school just to go look for your phone, correct?
Yeah.
With Taylor Perkins, your friend.
Yeah, I couldn't find my phone, so obviously I would go look for it.
But she didn't try to use her phone to locate yours, did she?
Yeah, she did. She would call and text my phone, but it would go straight to voicemail.
Right, but she did not use the Find My iPhone app, correct?
Well, no, because Samsungs don't have the Find My iPhone feature.
All right, and Samsungs do have Find My iPhone feature, correct?
Sorry, I can't.
I'll just move on. And just to recap everything that we talked about today, even through other witnesses, you spontaneously and impulsively wrote on Mr. Brackman's car, correct?
Yeah, I did. It
right.
was a stupid decision.
Right.
It was
then threatened to get
awful on my behalf.
The last thing you did, didn't you?
Yeah.
And then you coincidentally lost your phone, one of the most important belongings to any teenager, the day before the murder. With your friend Taylor Perkins as your only witness to corroborate your alibi.
Objection.
Sorry, can you?
Okay, Mr. Becker, would you mute your device, please? Ms. Maris?
Yeah.
Could you repeat your objection?
I objected to a compound question.
It was a compound question.
Honor, can I briefly respond really quickly? I asked a question to the witness and then he did not respond to my question, my first question, and I thought he did respond, so then I asked a follow-up question.
All right, so let's break it up into two questions, and Mr. Becker, if you would leave your device on mute, then answer the first one, then Ms. Gutierrez ask the second one, and then again, we'll do the same thing. It seems to work better, Mr. Becker, if you're muted while the attorneys are asking you questions.
All right. And then you coincidentally lost your phone the day before the murder, correct?
Yeah, I did lose my phone, but not on purpose.
All right.
No one loses their phone on purpose.
Right. And then your friend Taylor Perkins is the only person that can corroborate your alibi, correct?
Well, yeah, Taylor was with me the day I lost my phone.
All right. No further questioning, Your Honor.
Thank you. Redirect examination, Ms. Maris.
Yes, a brief one, Your Honor. Before I start at this time, can I request a time check?
Sure.
The defense has 3 minutes, 2 seconds.
Thank you. Now, Mr. Becker, how would you describe your work in mock trial?
I was good at mock trial. Good enough to win awards, and yeah, I would say I was a pretty good mock trialer.
What would you use when in competitions?
Sorry, can you repeat that? You cut out.
What would you use when you are in a competition?
Objection, Your Honor, vague question.
Yeah, I'm kind of at a loss. Ms. Merritt, can you be more specific?
Yes. Mr. Becker, did you use, I'll just move on from that question. Mr. Becker, how close were you and Taylor Perkins?
Best friends, inseparable best friends, I would say.
Have you two ever fought?
Yeah, like all friends. We disagreed on some things.
Do you think your friendship could end at some point?
Objection, Your Honor, relevant.
Ms. Maris, would you respond?
Yes, Your Honor. This is relevant because I am proving that Miss Perkins would not lie for an alibi for Mr. Becker on the day of Mr. Beckman's murder.
That's a real roundabout way of getting to that point. Can you think of a way to phrase the question that would allow Mr. Diaz to provide a more direct answer to that question?
Yes, Your Honor. Mr. Becker, do you think that your best friend would lie for you in every case?
No, no one would put themselves at risk of perjury just for their best friend. I mean, who would do that?
And lastly, Mr. Becker, why didn't you notice that your phone wasn't with you after you lost it?
Because I'm a normal human being. I misplace things often, and you know, like, yeah, I just misplaced him.
Thank you. No more further questions, Your Honor.
Thank you. You may step down. Any additional witnesses for the defense?
No, Your Honor, the defense side rests.
All right, thank you. All right, for the timekeepers, at this time is a real good time to check, make sure you have everything ready to go. Because I found that during closing, things get a little bit close to the number. And so if the timekeepers are ready and the attorneys are ready, let's begin with the prosecution's first closing argument.
Yes, Your Honor, may I start?
You may.
May it please the court, opposing counsel, members of the jury. I'd like you to think about fact and fiction. What have you learned today that is fact, and what is fiction? To clarify, I don't mean convoluted, multifaceted theories which have been force-fed by the defense in today's trial, but a reasonable story that has evidence. Let's start at the beginning. Mr. Brackman was coldly murdered on March 6, 2020. His body was found bloodied by his door, his kitchen in disarray with scuff marks and a broken plate. There's video footage of an intruder masked and attempting to enter his home before finally opening the back door and entering the home with the intention to commit some act of criminal mischief. There are no disputes to these facts that we've entered into today's trial. There's no dispute to what happened. It is simply a matter of who. Let's take another step backwards. Avery Becker was a talented mock trial student, award-winning with a bright future ahead of him. But he let anger and fury and emotion cloud his judgment, and he decided that he had to exact his revenge. After being removed from the mock trial team by Mr. Brackman, he graffitied his car with worst attorney, an act that could be, well, for the sake of today's case, likened to a stab in the back. But we know that Avery wanted to do much worse. After being officially removed from the mock trial competition, he texted his friend Alex Fuentes that he intended to break into Mr. Brackman's home and trash it. Avery Becker wrote, "That will show him." My co-counsel and I have the burden of proof in today's trial. We must prove 2 crimes and their subsequent elements. Avery Becker intended to commit a crime on March 6th. The proof that he did are in those text messages. That's not the only evidence we presented in today's trial. I'd like to walk you through the charges levied against Avery Becker. The defendant in Colorado on March 6th knowingly entered unlawfully into the home of Mr. Mackenzie Brackman with the intention to commit a crime therein, and that Becker, in the course of the crime of second-degree burglary, caused the death of Mr. Mackenzie Brackman. But members of the jury, may I remind you that our burden of proof is beyond a reasonable doubt. Reasonable doubt is defined as doubt based upon reason and common sense, which arises from a fair and rational consideration of all of the evidence, not a mere story of possibilities. When we find someone who looks like the defendant at the crime scene, when the defendant's phone is at the crime scene and the defendant was not at school when the murder was committed, and the defendant themselves told someone that they, quote, would get back at Mr. Brackman if it was the last thing they did, the only reasonable conclusion is that Mr. Becker committed the crime. Don't listen to these tall tales. There's also circumstantial evidence. Mr. Becker hated Mr. Brackman. He was impulsive. He had the tendency to act out and do illegal things when he was angry. That's just what he did. He was angry. So he went to Mr. Brackman's house. He trashed it. He picked up a knife, and in a fit of rage and fear, he stabbed Mr. Brackman in the back, leading to his death. And thus, the defense has tried to insert complexity into something quite simple, meticulous, and pristine. They've tried to cloud the evidence with what if this and what if that. Let me tell you, there have been an awful lot of coincidences for the defense's hypotheticals to actually be true. Blake Van Owen recited to you today coincidence after coincidence, as he was hired to do. He misinterpreted the same evidence we brought to you today with a flurry of alternative theories with little experience. There's no reality to the assumptions that Mr. Van Owen presented today. If anything, Mr. Van Owen didn't do his job. The only alibi presented for Avery was provided by his best friend, Taylor Perkins. Tell me, what would you do for your friend? Lie and protect them? Think about the way that they talked about each other, the way that they take care of each other. However, our experts, Detective Markowitz and Ms. Kuzak in today's trial, provided you two perspectives and 2 of the same theories. Alex Fuentes verified Avery's anger about his coach and need for revenge. Avery's desire and vindication brought him to Mr. Brackman's residence on March 6th. I urge you to consider these facts versus fables. Come back with a verdict of guilty on the charges of first-degree murder and second-degree burglary. Thank you.
Thank you. For the defense?
May I proceed, Your Honor?
You may.
Taking the easy way out leaves reasonable doubt. Your Honor, ladies and gentlemen of the jury, my name is Daniela Guadana, and today I represent my client, the defendant, Avery Becker. After my colleague and I finish our closing arguments, you will have the duty to decide beyond reason if the prosecution has proved to you beyond reasonable doubt that my client murdered Mr. Brackman. Instruction number 2 says, reasonable doubt is a doubt based on reason and common sense, which arises from a fair and rational consideration of all of the evidence, or the lack of evidence. It is a doubt which is not vague, speculative, or imaginary. After taking the easy way out, the prosecution and its investigators failed to discover little evidence. They failed to discover reliable evidence, and now a murder is on the loose. After consideration of such evidence and lack of evidence, you cannot find beyond reasonable doubt that my client committed a burglary, let alone a murder. Let's start with the evidence you did hear. You heard from the prosecution was never able to disprove Mr. Becker's alibi witness of Mr. Becker on the day of the murder. Ms. Taylor Perkins told you how well she truly knows Mr. Becker. He's a very rational person, rational enough to never even thought to commit murder. Ms. Perkins confirmed that Mr. Becker didn't even have his phone on him on the day of the murder. You then heard from expert witness Blake Van Owen, who told you how the police investigated with tunnel vision, only considering Mr. Becker as a suspect. They never looked into other suspects, like Blair Rollins. Mr. Blake Van Owen testified that Blair had motive, intent, and opportunity. Despite this, they never looked into her. Blair Rollins' father had been convicted for murder, and the prosecution took the easy way out. You then heard from the defendant himself, Avery Becker. He told you how he is a normal high school student who absolutely loves mock trial. Devastated by being kicked off, he did everything to try to make it right. But at the end of the day, this devastation is nowhere near enough to have made him want to harm Brackman in any serious way. The prosecution talked about how the whole case was about someone who you trusted betraying you. But ask yourself, who would kill someone for being kicked off of a mock trial team? Certainly not my client. You then heard from the prosecution witnesses, and none of you have provided you proof beyond reasonable doubt that my client murdered Mr. Brackman. You heard from Alex Fuentes, who provided you screenshots of an alleged text conversation between himself and Mr. Becker. But you heard Detective Markowitz himself and Blake Van Owen testify that these screenshots were never verified. Cifuentes had bias against my client. His friendship with Blair reassured this. They clearly set up my client to take the fall when Cifuentes himself and Miss Rollins stole my client's phone. You then heard from Kyle Kuzak, who came here today to convince you all of her conclusions regarding the crime scene. She thinks that the victim was holding the intruder in a bear hug before being stabbed in the back. She said this today despite the fact that the wound was very deep and that the murder must have been behind Mr. Brackman, not face to face. She also came here today to tell you that the knife must have been from the drawer, but this doesn't mean anything. She told you that the scuff marks indicate that there was a struggle, but I remind you, scuff marks cannot be carbon dated. You then heard from Detective Markowitz, who told you all about the evidence at the crime scene, which of course includes the completely lost and unrecoverable exhibits. Detective Markowitz confirms that the cell towers show that Mr. Becker was at Mr. Brackman's at the time of the murder. But I remind you, cell phones do not always connect to the nearest cell phone tower. Plus, the records only show where my client could have been, not where my client's phone could have been, not where my client was. Besides, you heard from the defense witnesses that Mr. Becker never had his phone. Instead, it was Blair Rollins who had much more motive than my client. She was the heartbroken daughter, completely overcome with emotion, waiting anxiously to get revenge on Mr. Brackman. The prosecution talked about about anger, fury, and emotions. What they do not realize is that Blair Rollins had all of these, much more than Mr. Becker ever did. Despite this, Detective Markowitz never followed the evidence straight to Blair Rollins. He took the easy way out and left reasonable doubt. Your Honor, ladies and gentlemen of the jury, today you heard about an investigation that was full of error and bias. It was dripping of reasonable doubt. I remind you, taking the easy way out leaves reasonable doubt, and now a murder is on the loose. You must find Avery Becker innocent. Thank you.
Thank you. I show the prosecution has approximately 45 seconds left.
Yes, Your Honor. Think about who you were in, oh, sorry. Think about who you were in high school. The stakes felt so high. With college around the corner and jobs and future prospects, the idea of someone tarnishing your perfect record seemed terrifying. Everything was black and white, right and wrong, life and death. Were you prepared to commit murder? Probably not, but Avery Becker was. The burden of proof is upon us. There's overwhelming evidence in our favor. Look at the exhibits we entered into today's trial and the lack thereof from the defense. Defense has tried to assert that Ms. Becker cannot be identified with 100% certainty. But we do know with certainty, without doubt, that Avery Becker committed this crime, and I urge you to return with a guilty verdict. Thank you for your time and patience in today's trial.
Thank you. All right. I will wait until I see the people who are responsible, the jury who's responsible for scoring this, and then we'll begin by having, once they're all back, having them introduce themselves and tell the people a little bit about themselves. And I think you kids did a great job, by the way. All right. Actually, why don't I save us a little bit of time? While the scoring panelists are doing their job, the jury, I'll tell you a little bit about who I am. My name is David Juarez. I am a practicing attorney in Adams County. I do primarily criminal defense work and personal injury work. I also am a part-time municipal judge for the city of Commerce City. And before that, I was a magistrate in the Adams County District Court. I've been involved in mock trial, some of you kids are going to love this, since 1986. It's been a long time. So I really love the job that you all do. I know this is hard. This is my first time doing mock trial by video, but just so that you know that what you do reflects what we do in the real world. Since March of last year, there has not been a jury trial, which is a lot of what my normal work would be. And almost every appearance that I've made since March of 2020 has been by WebEx, Zoom, or some other media device. We tend not to do evidentiary hearings by these devices, although sometimes it has to happen because it makes it very difficult for a judge to weigh the credibility of the witness and do the things that we normally do as judges when evaluating the testimony of witnesses. But reality has required us to do some of that, at least on preliminary matters, since March of last year. And the most recent notification I got is it looks like it's going to be through at least March 1st before we get to do a jury trial, and that's probably going to be pushed back again. The federal court, I think, has just notified me that it's still June. So it's going to be a while before we do real jury trials. So what you're doing is what we've been doing since March of last year. That's pretty much it for me. I see, I believe it's Mr. Scarponi is back. Have you already turned in your score sheet, Andrew?
Yes, Judge.
All right, if you would, go ahead and tell the kids a little bit about you, and then you know, whatever comments you want to make with regard to the presentation.
Sure. Hi, everybody. My name is Andrew Scarponi. I am a recent graduate of CU Law, and I am working for, yes, and I am working for the State Department of Labor. I thought you all did a great job under what we all know is extraordinary and unusual circumstances. I think that everybody did a good job of accommodating the reality of a remote argument. Although some of the advice that always comes out in live argument is maybe even more true here, that when in doubt, slow down. And that'll make it easier to hear and less risk of overlapping. But nice job, great preparation, everybody, and keep up the good work.
Your Honor, you're on mute.
Thank you. Ms. Forbes, have you finished turning in your sheet?
Yes, yes, I have, Judge.
Go ahead. You want to tell us a bit about yourself and whatever comments you want to make?
Yes, I graduated from DU Law in 2009. And since 2011, I've been working as an assistant U.S. attorney for the United States Attorney's Office in the criminal division. So I'm a federal prosecutor. And back when I was in law school, I loved mock trial. I did competitions. I also coached high school mock trial. So I know how you all feel. And I just want to commend you, sort of echo what Andrew said, that what you do takes so much work and so much commitment, and then especially to commit to doing it now, and the struggles with having to do it, technologically in this format. I just am very impressed with all of you. You were all very clearly well prepared, and even with some minor technical snafus, we were able to get through it, and you were all able to do it with professionalism. And so I just commend you on doing that. In particular, I thought that in general, the direct examinations on both sides were very good. In particular, Ms. Gutierrez, I thought that you did a great job with your expert foundation and tendering your expert and getting evidence admitted. Ms. Udeshi, I thought that you also were very good at getting your exhibits admitted, and you had excellent responses to objections. Ms. Guadana, I thought that you were clearly prepared for your expert admission as well, and you had a great response to the voir dire that happened by opposing counsel. Ms. Mayers, I also thought that you had a good demeanor on direct examination and a good flow. Mr. Bloss, in particular, I thought that you did great on cross-examination. A thing that attorneys forget to do a lot is when you win an objection, finally, they forget to repeat, to remind the jury where we were before all of that happened. And so you did a good job of repeating your question after you won an objection from the judge. And Ms. McDonald, I thought that, again, you also did a great job on direct, but also your closing was very well done. You did a good job walking through the elements and the law and laying that out in combination with the evidence that was presented. And I also want to commend the witnesses. I thought they all did a great job. In particular, Miss Charaja, I hope I'm saying that, the one who played Kyle Kuzak, and Mr. Diaz did particularly good jobs, not going too far in cross-examination and sticking to their witness statements and not fighting back. And I thought they did a good job.
Thank you. Mr. Petrie, looks like, have you turned in your score sheet?
I have, Judge. Thank you.
All right, go ahead.
My name is Drew Petrie. I'm a partner at Ballard Spar in Denver. I do exclusively civil litigation and have done it for, shockingly enough, 40 years. My criminal law experience ended in law school in 1979. I second everything that's been said in advance of me. You all are really a pleasure to watch, given the level of preparation and level of skill. I had two suggestions. Andrew mentioned slowing down, and I agree that that's very important. And it's also important every now and then to take a pause and let what you're saying sink in so that the jury understands and has a minute to digest what you've just told them, rather than running pell-mell through everything. I know you have time constraints here, but sometimes it's important to just breathe a little bit and let the jury digest what you've told them. And that's in your examinations and in your opens and your closes. Those are important speaking tools that you can use. The other thing that's kind of a personal note that always struck me as being a little bit odd. We're so concerned about being polite and being respectful to the judge, which is entirely appropriate. But I don't think you need to thank the judge when he goes against you on an objection. It always strikes me as being a little bit anomalous. It's kind of like thanking someone who's just slapped you in the face. And because of that, my practice is that I don't thank the judge when he or she go with me on an objection, just because if you have a pattern of thanking and then when you lose, you don't thank, it makes it stand out even more. It's the judge's job to be the referee. The judge does her job or his job, and you just deal with it and move on. Just a very minor suggestion for you. Thank you.
Thank you. And I'm going to say Popovich. Is that how you pronounce it, Paul?
That is correct. That's right. Silent H. There's a little accent mark. So
there you go. And I'm assuming you've turned in your score sheet.
yes, I have.
All right, let's go ahead and tell the team members a little bit about you and your comments.
Sure. So my name is Paul Popovich. I practice at Hall & Evans. I represent employers, insurance companies in the defense of workers' compensation claims. I've been participating in mock trial for maybe 4 to 5 years. At the outset, despite doing it via Zoom, I thought the professionalism, the level of competition, everything was up to par with what I've seen in previous years. So well done by everyone. I'm very impressed. You're looking into a computer. I'm doing it right now. It's very awkward, right? But great job by everybody. And two thoughts that are more general. There's too many to go specific for everybody, but for the attorneys, I think there were some great examples of really listening to the objection and then directly addressing it. So, it's one thing just to make objections, but try to make them targeted to the facts and then really listen to any kind of counter argument so you can be specific to that. And then for the witnesses, I think what stands out when you're just watching this is someone who really jumps into the role and pretending they're the person and responding naturally and not being too argumentative. You know, it's okay to concede facts that are in your statement or whatever. You don't have to fight every point. And that's fine to concede that and just sticking in that role and not being an attorney and arguing, but just being that witness and playing. And I think there are some great examples of that today too. So excellent work, everyone.
Thank you. And then Ms. Legel?
Can everybody hear me and possibly see me? Hi, I'm Christine Legel. I am also a civil litigator, but I have not been doing it for 40 years. I've only been doing it for about 6 years now. And I'm also a mentor attorney for Colorado Springs Court. So mock trial and teen court have been near and dear to my heart for the last 15 years. I was in your shoes one day, and I don't think I would have handled the technology half as well as you folks are. I have to say, I am incredibly impressed at the use of technology, using the exhibits, sharing your screen. I've had bench trials where I have not been able to get my exhibits in because I didn't know how to use WebEx for the court. So kudos to all of you for handling that as well as you have. The one piece of advice that I will tack on to all of the advice you've already gotten is try not to talk over each other. It's very, very easy to do when you're doing it through a screen. You know, you're not always able to see when somebody is still talking or when they are trying to interrupt. So along with taking a breath, giving yourself a little bit of time to think through what's happening, let your witness finish answering the question. Even if it's not an answer that you want, let them finish. Let the attorneys finish asking their questions, and it's going to make it go a lot smoother. But overall, guys, I've seen attorneys put on evidence, you know, not half as good as what you guys are doing. So good job. I'm really proud of all of you.
All right, thank you. Just a couple of comments that I want to make that might assist you going forward. And a couple of you, during your examination, the attorneys, you started to do what I call like head notes. You said, I'd like to talk to you about this before actually asking the question. One of them was talking about the vandalism of the car and then moving on to another topic. You don't really need to tell the witness what you're going to be doing. You don't need to provide them like head notes, things of that nature. Just ask the question. One of the attorneys said to the witness, I want to advise you to keep your answers short or just answer yes or no. When you're cross-examining a witness, just ask the leading question. As a result, if you ask the leading question properly, the answer you're going to get is a yes or a no or a short response. So, you know, you don't need to instruct the witness if you ask the leading question properly. And just keep that in mind as you're going on. I thought, again, because of the time constraints, that you were a bit rushed, but it's always good, as Mr. Petrie said, to kind of pace yourself. Look for some impact with the jurors for the question that you've just asked and the answer that you expected to get before you move on. And again, I realize that there's time constraints, but for the most part, those are the only things that I want to bring up. I don't think I'm supposed to open this up for general questions, but you know, I'm waiting for our courtroom monitor to tell me that we're done. And so if students want to ask any questions, please feel free.
That is correct, Judge. We're not open for general questions. My coordinator has confirmed receipt of all of the score sheets, so this courtroom is dismissed.
All right, well then everybody's free to leave the meeting, and good luck to everybody. I'm sorry, Elizabeth, there was something else?
Thank you all.
All right, thank you.